copies. And this is a letter of support.
And I think there's a letter from the South Palmer Improvement Committee, said they have no
You have the
objections
file?
to the transfer as long as the MOU is signed. We have the MOU that we've signed. Mr. Busher's been the licensee there for the last 10 years, and there's going to be no change. It's a 6-day operation.
Exhibit 1,
Exhibit
Exhibit
1
2.
Okay.
and Exhibit
You
2.
going to present any testimony?
Other than he's the licensee.
Yes or no?
No.
Okay. Any questions, commissioners?
None.
I'm clear, so this is a change of ownership, not just a corporate name change?
He's an owner, he's forming another LLC, so he's transferring from himself as a licensee to another LLC where he's the sole owner.
Okay. Why are you doing that?
There-
I'm just curious why.
There's another group that's buying the building,
Mhm.
which he was a part of, so they're gonna redo the whole building and upgrade everything. So, but he's not part of that group that's buying the building. So they don't have a separate lease with them.
Okay. Do you currently own the building, or do
Yes.
you currently own the building?
You guys can.
Oh, does he currently
Unless
own the
unless you
building?
want him sworn,
The
I'll have him
LLC,
sworn.
yeah.
I'm trying to follow
You
the
want him
bouncing.
sworn?
No,
The
no.
LLC, the TCOT, that,
Wait till they finish before you speak.
we'll put his name on a record one of these days. Yeah, the LLC, TCAT owns both the license and the building, so they're selling it, and then he's going to stay on it as a different LLC.
Okay, thank you.
No, no other questions?
No other questions?
All right, time for decision, yes.
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 All right, you have our decision. Mhm. All right, call the next one, when he's ready.
Mr. Kadinsky, could you have your client come? There's some transactions your client needs to take care of.
Morning.
Morning.
Okay, the next item is Matthew Pierce, Harlan Inc., trade name pending. This is at 225-227 West 23rd Street. This is a Class D, Class D, beer, wine, and liquor. Application for transfer of ownership, request for outdoor seating and off-premises catering.
All right, swear all witnesses.
Raise your right hands, please. You swear or affirm the testimony that you're about to give in this hearing. Raise your right hand. Let me start over this guy. You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Okay, and your counsel, enter your appearance.
Abraham Bertle for Harlan LLC and Matthew Pierce, the applicant licensee.
This is your case. Glad to hear from you.
Mr. Pierce, you plan to open and operate the restaurant at 225 and 227 West 23rd Street, is that correct? Yes. How much experience do you have operating a bar?
Been working at the bar, but I've assistant managed now with my wife for 2 years. We've been open for 2 years. And been in business before that for a number of years.
Have you had any violations during that time?
No, we've not had a single violation in the 2 years we've been open, but we do have lots of accolades and awards that we've won. Best of Baltimore is in the paper, that we've been open, Washington Post, New York Times Magazine, Baltimore Magazine, but no citation.
Are these some of those articles that you've been cited in?
Yes, they are.
I'd like to submit these as petitioners one.
Sure. Now, these are, commissioners, your exhibit 1 collectively, is that correct?
That's correct. These are various articles.
Are these recent articles?
Well, they've only been open two years, so
Some are from this year, some are from the first year that we were open.
you recently won the City Paper Award, is that correct?
That's right, this year and last year.
And you indicated you had no violations, no noise issues, anything along those lines?
Not a single one.
Have you had any complaints that you're aware of, really?
No, not
And as part of your
Exhibit one.
application, you reached out to two of the community groups here, is that correct? And I believe there's a letter of support from, I believe, Rita in the file. Is that correct? Yes. I'd like to enter that as a petitioners two, if possible.
Yes?
We also have a letter.
You need to speak into the microphone. This is Exhibit 1.
Okay.
And this is Exhibit 2. Maybe you could just raise it up a little.
Just move in front of it.
But you also have to speak into it, and you have to speak louder.
Okay,
Thank you.
sure.
Thank you. You also went door to door in the neighborhood, getting people on 23rd Street, asking them if they approve. Is that correct?
That's correct.
And this is that document?
This is the, yes, signed petition from people that live on the same street as the business.
It's also your, I'm sorry, I apologize, petitioners 3 if possible. You're also aware that several letters were submitted into the file supporting the application. Is that correct?
That's correct.
I believe they're already in the file, commissioners. I'd like to move those in as petitioners 4.
Exhibit 3. And also introduce the file, Exhibit 4.
Thank you, Chairman. In addition, we have some extra petitions that came in just today. Is that correct?
That's correct.
And we'd like to introduce those as petitioners 5.
Thank you.
This is some more letters from neighbors in the area. As part of your application, you're applying for outdoor table service. Is that correct?
Yes, sir.
What are you, right next to Remington?
We're in Remington, yes, sir.
23rd and Remington.
Oh, I thought you meant the neighborhood. It's
No.
23rd and Howard, between Howard and Huntington.
I have a zoning map, if I may submit that as petitioner 6. It indicates the exact
Five,
location,
I think it is.
Or 4.
4.
and it reflects the zoning code, which is an M22, which permits as a matter of right outdoor table service, which has been applied for at this time.
Now, what is what on here? You got all these red marks.
Sure, I apologize. If you, this area here indicates it's a B33, and this small little box is an R7. The large kind of open space is the M22 zone,
So where are you?
with a little pink dot.
I also have photos, large photos, if you'd like to see them.
Say that again.
I have
We
large
have some
photos.
blow-ups for the board to take a look at as
It's
well,
up to you.
to represent the area. Yes, please.
Exhibit, whatever it is. 5, 6, whatever. Yeah, the file, I
Alright.
think, was 5.
Okay,
It's 6.
so this will be number 6.
Here are some photos of Corky's, and this is the view towards Howard, is that correct?
That is correct, yes.
And this is Corky's,
Yes,
and this is the view, I guess, from Howard inward.
that's correct.
And here we have I believe it's a Google map of the location. Is that correct?
That's correct. This is Howard, and this is the location.
And based on your knowledge, the only homes for residents nearby are going to be over here, is that correct?
That's correct.
And you plan to have your outdoor table service along this side?
That's correct.
Which side?
The main street side, so that the noise wouldn't carry down the road, it would be on this side. So it'd be this,
And that's Howard Street?
no,
23rd.
This is 23rd here, yes.
this is Howard.
Okay.
So it's a half a block off of Howard. This is Howard.
The area is largely industrial, correct?
That's correct.
Thank you. And I submit this as petitioner 7. I guess I can pass over when we're.
Yeah, we used to call it an Italian community, still over there.
Pasadenes, yeah. There's a lot of them that still live there.
Go ahead.
At this time, I have no further questions for the applicant. I do have some other witnesses, other people who will testify that they believe that this is a good project.
Your case, sir.
Thank you. Now you can step down.
Well, what about cross-examination
Oh,
of
I
him?
apologize, absolutely.
Are you counsel?
No, I'm not, sir.
Anybody counsel over here?
Community associations.
All right, you represent somebody?
Yes, I do. I represent the Remington Neighborhood Alliance. I see you have the letter in front of you. This is the signed original copy for you.
Okay, you want to,
And I have,
when you present your case, you
fine,
can,
thank you, sir.
you have any questions?
No, I don't.
All right, commissioners' questions.
I'm just trying to get the perspective. How far is this from the car wash on Howard Street?
It's about a block. The car wash
A block
is-
north or south?
It's a block north and half a block west. So if you're coming up Howard and the car wash is on your left, about the next block, you would turn left and it's down
Okay.
on the left.
If I may follow up, you also have your wife runs as the manager at WC Harlan, correct?
That's what the letters and the awards that I gave you were for, the business that we, yeah.
The next question, what is it that, and are you a licensee on WC?
No, I'm an assistant manager there. and we've run it for 2 years. We've been open for 2 years. That's when my experience in the industry was mostly from this place.
All right, I think that's it for me for now. Thank you.
May we call Brian?
He's been sworn. Your name, sir?
My name is Brian Weeks. Thank you for the opportunity to speak and vouch for Matt and Lane. I am a resident of Remington. I live on 3103 Huntington Avenue in North Remington, probably about a half mile from where this location will be. I'm here today just to vouch for Matt. On a personal level, I've known him for about 3 or 4 years. We play soccer together. I've always known him to be very forthright, honest, and Lane as well. And, you know, I was fortunate enough to attend their wedding and just have become very close to them over the years. I knew them before they opened WC Harlan, and I know the amount of work they put into opening that place and the attention to detail that they, you know, they really poured their heart and soul into that place, and it's reflected in the awards that you all have in front of you. And I think that same attention to detail extends to their relations with the community. You know, they've been very active in, both my wife and I are GRIA members. They've been very active in coming to the GRIA meetings and presenting their plans for this new project. And, you know, as Matt mentioned, they haven't had any real issues at their WC Harlan establishment. So just here today really to urge you as a native of Remington to approve this transfer. Thank you.
Hey, wait a minute, sir. Any questions? Any further questions?
Brian, what do you do for work?
I'm an attorney. I work in the Attorney General's office.
No further questions.
Any questions, sir?
No.
All right, questions, commissioners?
None.
Jenna, you please.
Wait a minute.
Sorry. I apologize. I'm
Say
sorry.
now.
Sorry.
Yeah, slow down, everybody. Can't keep up.
I apologize. I'm just.
You have to tell me whether these people have been sworn or not.
I don't think so.
She has not.
Swear to witness.
Right hand, please.
Can't keep up. There's just absolutely no way to keep up. Do you swear or affirm the testimony, raise your right hand, please. Do you swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Jenna, can you please state your first name and spell your last name?
It's Jenna Hattenberg. It's Hattenburg.
Jenna, where do you live in relation to the proposed transfer site, Corky's?
I live about a block and a half. I live above WC Harlan.
So you live above the other bar.
I do.
Have you had any problems living above their bar?
I have not. It's very quiet.
And do you support the transfer?
I do, wholeheartedly.
I have no further questions.
All right. Any questions, sir? Commissioners, questions?
Just one. Who owns the building that WC Harlan is located in?
I deal with Lane and Matt. I'm not.
Are they your landlords?
They are, yes.
Okay. And did they ask you to come in today and testify in support of them?
Yeah, I volunteered.
You
to come in.
volunteered?
Mhm.
Okay. All right. Thank you.
Can I follow up?
Absolutely.
Jenna, were you promised anything in return for coming today?
No, not at
And you
all.
did so voluntarily?
I did, yes.
Thank you.
All right. You're excused. Next witness.
What do you? Woody, can you please state your name and,
both raise your right hand.
Yeah, James, raise your right hand. Okay, raise your right hand.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do, we do.
Woody, can you please state your first name and spell your last name for the,
It's Woody Rainier. It's Ranere.
and Woody, where do you live in relation to Corky's?
I live about 7 blocks away. I've owned a house there for about 8 years. It's on Guilford, 25th and Guilford.
And have you been to WC Harlan?
Yes, it's right around the corner from where I work. I work on Fawcett Street.
And do you support the transfer of Corky's to Matthew Pierce as the licensee?
I do.
Could you have the witness number 3 to repeat himself, please?
I think you should have the judge's gavel.
I don't know if I'm going to do that.
And were you promised anything in return for coming here today?
No.
Thank you. I have no further questions.
Questions, Commissioners?
No questions. It's an incredibly cute little boy.
Oh, well, thanks.
Very cute.
Thank you. Sir, have you been sworn?
I have been.
Can you please state your name for the record?
My name is Ryan Flanagan. I'm the Vice President of the Greater Remington Improvement Association. I believe you have our letter, and I just want to make sure that it's in the record that we enthusiastically support this enterprise, as we did when WC Harlan's first opened, and they proved to be conscientious neighbors. They came before both our board and our membership, and were thoroughly vetted, and they, I've had people knocking down my door asking for where can they sign letters of support to submit to y'all, so this has been a very enthusiastically supported project by our membership, and that's it. Great. Supports it fully. Thank you.
I have no questions for this witness.
Commissioners?
Just a couple. So
Sure.
the, where this is going to be, how is that going to be impacted by the plans to redevelop the Anderson Honda area?
I mean, it is not immediately adjacent to those properties. It's about 2 blocks south of them, or I guess a block south, but between them and that redevelopment is the R.E. Harrington construction lot, so there's it's a very physical barrier between it.
Okay.
This is almost, in some ways, I don't want to say isolated, but it's a little more distant and cut off from the rest of that.
So it's a little bit closer to Liberty Roofing?
Yes, it's on the same block as Liberty Roofing, and the furthest end of the block is also an R.E. Harrington lot that abuts the gas station where Washworks
Okay, and the
does as
reason
well.
I'm asking is I know that there are plans to bring in a number of residences. I don't know, well, but there were
Eventually,
plans
yes.
to do that.
Mhm.
I just wanted to know if you could foresee that there would be residences in that area that could be impacted by the
Even
bar.
none of the buildings that are adjacent to the current site, Corky's, are slated for redevelopment. They're not in the Anderson site, so while I can't, I don't know what's happening, I don't know what I don't know, but there could be no future impact from the 25th Street redevelopment. The closest houses are the ones down on that 2200 block of Huntington, and they are not even immediately adjacent. There's a couple buildings between Corky's and those residences. And so yeah, they're the most immediate neighbors, and the next are, again, about another half a block on the other side of the Roland Roofing Company is the 23rd Street, Fawcett Street, and those neighbors.
Okay, and the only other question, do you know how many other bars are already in that area?
There's only WC Harlan's. The next closest liquor license, I believe, would be on Maryland Avenue in one of the some of the restaurants along there. And then the next one would be at 3 Miles House on Miles and 27th, or maybe something at 25th Street, but it's a couple blocks in any direction.
Okay, all right, thank you.
I have a couple follow-up questions. I apologize. This is an existing location, correct?
Yes,
It's been there for years, to your understanding.
as long as anybody can remember.
And currently WC Harlan, which Matt is the assistant manager at, and his wife is the owner and operator of.
Yeah.
They live in that location's in a residential neighborhood, correct?
Yeah, it is in a corner row house with someone living above it, and people next door, across the street, sharing the alley, is in a residential context, yeah.
And to your knowledge, they've always been conscientious neighbors and managers as well.
Yes, I know preceding the opening, there was careful negotiation about how the entrances was used, because there's a front entrance that enters onto 23rd Street closer to the residences, and a side entrance on Hamden Avenue, and they have exclusively used the Hamden Avenue entrance to decrease the impact on the neighbors.
Right, so there's an existing bar,
Yes,
and it's in operation.
yes, and like I said, as everyone has said, there's been no violations, and we've heard no complaints on our end.
For the existing bar?
Yes,
And they've been there for how long?
2 years. But it was, that has been a bar since Prohibition is the commonly cited date.
Okay, so I just want to get clarity. So this is an application to transfer ownership,
Yes.
and it's to transfer the ownership of the existing bar.
Corky.
I apologize. I think my question confused the matters. There is I apologize. WC Harlan operates down the street. Nothing is changing with regards to that. Matt has been the assistant manager there for 2 years. It has been well received by the neighbors and newspapers and magazines, and we're using that as a reference just to say that he is obviously very qualified based on how good it has been. The location that's being transferred is Corky's, which is 225 and 227 West 23rd Street. It is open operating. I spoke with a licensee myself yesterday who asked if he needed to come. He unfortunately is very busy this time of day doing lunch. And it's to his knowledge, and I I'm just relaying what he informed me of, that they've never had any real issues there. And they, it's just, you know, the licensee's been there for as long as he can remember.
And the license is valid?
Yeah, the licensee's been there since 1991, the Carabella's.
Mhm.
And looking at the card file for this, there haven't been any violations since they've taken operation since 1991.
Oh.
And the license has been in existence since 1934.
Okay.
Wow.
That's a good one.
But I think
Great.
that is prohibition,
Yes,
right?
it is.
Yeah.
I think so.
Okay. All right, thank you.
Anything else? Your excuse, sir.
I'd like to recall Matt, I guess, very briefly, if that's possible. Matt, you did reach out to both community groups, is that correct?
That's correct.
Were you asked to meet with either of the two community groups?
GRIA, yes,
So the other community group never got back to you to arrange a meeting, is that correct?
that's correct.
I have no further questions.
Anybody questions?
Yes, how
Wait a
many?
minute.
oh,
Sir?
I think I can address that when I make my presentation.
Okay. Commissioners?
How many times did you reach out to, you reached out to Remington Neighborhood Alliance?
My wife actually sent the emails, I think 3 or 4.
Well, you can't ask anybody else. So to your knowledge, 3 or 4 emails
A
went
few
out?
times, yes.
Okay, and what was the response?
None.
Okay.
Anything else?
I'm going to call his wife, just to...
And that's the last one?
That's the last one.
Okay. Are your excuse?
Thank you.
Call the witness.
Lane, you can come up.
She needs to be sworn.
You've been sworn?
Not yet.
Swear the witness.
Raise your right hand. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Lane, you're the one who actually reached out to
Your
the...
name?
My name is Brittany Lane Harlan.
Okay.
Ms. Harlan, you reached out to the Remington Neighborhood Association, is that correct?
Yes.
And when did you reach out to them?
Some point in November.
Was it early November or late November?
I don't remember. I have the emails printed.
If I showed you those emails, would they refresh your recollection?
Yes, they would.
Did you see them?
They're Google Docs.
Lane, is this those emails?
Yes.
Based on that, when was the first time you believe you reached out to them?
Looking for the date. Looks like November 10th.
And did they at any point request you to attend a meeting of theirs?
No. In fact, I tried to gain an audience there, and there was no response. Just every time I would ask to go to the meeting, the president would just ask me another question or not respond.
Thank you.
Questions, sir?
No, I think I can address that.
Okay. Commissioners, questions?
No questions. None.
All right. Anything else? That's your case?
That's everything, Your Honor.
All
Thank
right. Come on over, sir.
Oh.
You've been sworn, and your name.
Douglas Armstrong, Vice President of the Remington Neighborhood Alliance. I am here in lieu of the President, Joan Floyd, who is unfortunately unable to attend.
And where do you live, sir?
I live at 2828 North Howard Street,
Mm-hmm.
several blocks away. I am not anyone with standing.
Say that again.
Nothing, I'm just being facetious.
Oh.
You have in front of you, as I emailed this morning, the letter from our community association, but I will read it to you just as well, and then elaborate on 2 points.
I would have checked it this time. I haven't seen the letter.
I have a copy.
Thank you, Your Honor.
He's giving him one.
I'll give you that one.
I just gave it to you.
Well,
Okay, let me know when you're ready.
Dear Chairman.
Wait a minute. Let me know when you're ready.
all set.
All right, sir.
Thank you. Dear Chairman Ward, the Remington Neighborhood Alliance, RNA, has been reviewing the application of this transfer and has communicated with staff on some issues. While staff have been helpful, problems with the application remained as of our December 10th review of the file. Firstly, we have seen no evidence that Matthew Pierce is a registered voter and Baltimore City taxpayer, as he is required to be under Article 2B, Section 9-101B. I was informed by Mr. Akras of staff that an affidavit supporting Mr. Pierce's qualifications under 9-101B would be in the file for our review, but no such affidavit was found in the file yesterday. Without information to review and verify, we assume Mr. Pierce is not a registered voter and is not a Baltimore City taxpayer, and therefore Harlan Inc. is ineligible for the transfer. Secondly, we do not understand Mr. Pierce's statement that he is the sole owner of the new enterprise and will be its full-time operator, and that Brittany Lane Harlan will have no financial interest in it. Ms. Harlan currently owns and operates the licensed business at 400 West 23rd Street, according to the Liquor Board files. It is generally understood in this community that the new business will be Ms. Harlan's as well. Please see the attached November 6th email from Ms. Harlan, in which she promotes, quote, our new restaurant plans, end quote, to the RNA and makes no mention of Mr. Pierce. See also her November 10th email, in which she states, quote, we applied for the liquor license transfer last week, ... We will still operate our original location, end quote. In fact, only Ms. Harlan, a non-applicant, has ever contacted the RNA about this transfer application in spite of a Liquor Board letter in the file requiring Mr. Pierce to do so. It is the responsibility of the RNA, the Civic Association for residents of Remington since 2000, to ask this board to protect our neighborhood by ensuring the eligibility of any new licensee and the veracity of representations made on liquor license applications. And you will see on the other side, I think, the sum total of those communications as stated by Ms. Floyd.
I have this.
Well, this is the original. That's a copy, sir. I would merely
All right, wait a
state
minute.
that
Exhibit number 1.
Can I question him with regards to this? Is that
Yeah,
possible?
when we get to it.
Thank you.
Go ahead, sir.
I would merely say that I have as well some additional copies of emails between Ms. Floyd and Mr. Akras and staff concerning the concerns of the application, if I may so submit those. And
I would object at this time. I have not seen them. I have not.
I will,
Go ahead.
and,
Let them have a chance to look at them.
yes, sir.
And you're going to tell us what they say?
Well, just that there have been various
Exhibit 2.
questions about the application and the,
Exhibit
whether or
2.
not it has been properly filled out and has been properly verified. As far as I know, as of yesterday, when I looked at the application, there still had not been any indication of property owned by Mr. Pierce that he pays tax on in his own name in the city of Baltimore, and no verification of his voting, of him being a registered voter in Baltimore City. All we're asking is that the rules of the Liquor Board and the application requirements be met in order to have an appropriate transferee. And the only other thing I would add, besides what is before you and is all on paper, is my own observation, and that is this is not a plebiscite, sir.
This is not a what?
A plebiscite. It's not a popularity contest. It's a matter of fulfilling the legal requirements and obligations. This is a big obligation to be granted a liquor license. I think you're well aware of that, all three of you. So I will answer whatever questions I can.
Is this a transfer?
It's a transfer, but it's the assumption of a liquor license to someone who doesn't and hasn't owned a liquor license.
Well, of course, the law is, the transfer is the character of the person
True.
receiving the new license.
That's one element, yes, sir.
All right, do you have any questions, you said?
You said you went through the file yesterday, Mr. Armstrong. Is that correct?
That is correct. You'll find a letter or a note that I looked at the file yesterday morning, 11-ish.
And Mr. Armstrong, in that file, did you see a letter from Mr. Akras to the executive director of the Liquor Board?
Which letter would that be?
Mr. Akers wrote a letter to Ms. Bailey Hedgepath, the executive director,
Yes.
regarding the taxpayer.
Yes,
comment you have?
I have had a chance to read that.
And in the letter, it indicates that as a renter, his rent filters down and makes him a taxpayer in the city. Is that correct?
Well, that's a legal theory premise that I've heard put forward in other instances.
Mr. Armstrong, I didn't ask in other instances, I apologize. I asked in that letter, Mr. Akers, the deputy secretary of the liquor board, wrote to the executive secretary of the liquor board that it is his opinion that as a renter, tax money filters down and therefore makes him a taxpayer. Yes or no?
That is his opinion in the letter, yes.
And you indicated that there was some confusion as to who was the owner of the business, is that correct?
Well, as you can see from the emails that are presented in the exhibit, they are only between Lane Harlan and the president of the RNA about her new business. There is no communication whatsoever between Mr. Pierce and the RNA asking for a meeting, representing that he wants to transfer a license, that he is the applicant, that there's any information whatsoever. It is solely and exclusively Lane Harlan who made those communications and has represented it as her business. Now, if that was incorrect, that could have been cleared up in the communications back and forth, but as far as I know, you have what you have. I would
Yeah,
merely...
I do have a question. I'm confused as to where Lane represents that she is the owner. There's a lot of we and our, but they are married. You're aware of that, correct?
I'm aware of that, but is his name listed in any of those communications? Is Mr. Pierce listed? Is Mr. Pierce referred to? Is Mr. Pierce given as a contact in any of those emails?
You understand that sometimes a wife may help their husband and vice versa, correct?
I've been married for 37 years.
And who's your wife?
My wife is Joan Floyd.
And you're here on her behalf to help her out?
I'm here on the behalf of the RNA, the Remington Neighborhood Alliance,
Because Joan Floyd couldn't be here?
because Joan Floyd is otherwise engaged. But I also know that not necessarily does one partner have the obligation or the responsibility to perform the duties that are the obligation or responsibility of the other partner. And in this case, Mr. Pierce is the applicant, not Ms. Harlan.
Have you had a chance to look at the articles of incorporation for Harlan Incorporated?
I've only glanced at them.
Is Lane Harlan listed anywhere on the articles of incorporation?
To my knowledge, she is not.
To your knowledge, does she own any stock in that corporation at all?
No, I don't. I have no knowledge as to whether or not she does or doesn't.
To your knowledge, does Mr. Pierce own any stock in W.C. Harlan?
The only question here is whether or not Mr. Pierce fulfills the requirements of the law. Is he a taxpayer? Is he a voter?
I object to that answer.
And does he? And if, as the sole owner and stockholder of Harlan Inc., and he fulfills those requirements which are in the code, then I guess he's kosher. But that is the crux of the matter here. Does he fulfill the requirements of 9-101B? I can never remember that, sir. And the only other thing I would say to that is I did take a copy of a letter written by Jane Schroeder to Corky's on 3/22/2012
I object to this document.
that says,
I
well,
haven't-
Sir,
I have
you
not
have
seen
your
this.
opportunity to speak when your time is appropriate. Let him present his answer to your question. Go ahead, sir.
I'm sorry, Your Honor.
I'll
He's
take that.
presenting evidence, though. He's reading from the document. It's not in the
Well,
record.
whatever he's doing, you can tell me later that you don't like. Go ahead, sir.
this is a copy of a document in the Liquor Board's files for Corky's, which is the establishment to be transferred to Mr. Pierce. And it is a letter to the licensee that specifically says in number 5, other, quote, to qualify as a city taxpayer, taxes must be paid or property owed in the individual name. Do you own other property in Baltimore City is in your individual name? That is from Jane Schroeder. So I would say that that is a contradictory position to the one Mr. Akris has taken.
Well, I have to tell you,
And-
I disagree with that.
It's fine.
Ms. Schroeder. And I think that the person who wrote the decision in the Court of Special Appeals concerning a definition of a taxpayer is not following Maryland law, which is very clear. Maryland law says when the legislature speaks, it says exactly what it says. And the legislature simply said, you have to be a taxpayer.
Okay.
They did not put any qualifications as the Court of Special Appeals decision. I totally disagree with it. So.
That is
Ms.
fine.
Schroeder
This
hasn't been
is,
here for years.
well, she hasn't been here since 2012, so.
Well, last time I saw her, she was in community service over at East Baltimore. It was about 40 years ago, but.
I'm merely
I didn't know she worked for the
presenting,
liquor board.
I'm merely presenting the concerns and the evidence with respect to who's contacted who on.
Which you have a
Yes.
perfect right to do.
Thank you very much, sir. That is all I need to say. That's all I want to say.
Now we'll hear from you. Did you have an objection?
Yeah, my question was or was he not aware that Matthew Pierce doesn't own any shares of WC Harlan?
And he answered that.
Okay, I have no objection.
Okay. All right. Now, do you have any other witnesses?
No, I'm not. I was presumably just reading a letter and.
Is that your testimony?
That's my testimony.
All
so
right.
I don't have
Commissioner
anything else.
questions. Commissioner questions.
I just have, oh,
Mr. Jones?
She can go first.
no, I would gladly defer to you.
No, she says,
He wants me to go.
everybody wants to be first. Second.
Yeah, right. My question is for you, Mr. Armstrong. If this licensee does meet the qualifications for ownership,
Then as far as I'm concerned, that is the litmus test. Like I said, it's not a plebiscite. It's not a matter of whether I like it or not like it. It's whether or not they meet the requirements.
all right, and so let me just drill down a little bit. In terms of their concept and
I have
what they
n-
want to do, you have no objection to
I
the
have
concept?
I actually don't know anything about the concept. I have no knowledge of the concept.
Other than
so-
what you've heard this morning?
Other than what I've heard this morning.
Okay.
Exactly.
So just so I'm clear, your issue is, does this licensee meet the qualifications?
Meet the qualifications,
And that's it?
precisely.
Okay, all right,
That's the crux of the matter.
okay, all right, thank you,
All right.
thank you.
Now, that's your case.
Well, it's not much of a case in the sense that that's
No, when I-
your requirements and the board's, and the office's requirements to see that those
I'm
things
merely,
are met.
see, I'm the chairman of the procedure, so I have to see that everybody's had their say.
Right, yeah, but
Now,
I'm not
do-
an attorney, so I don't have a case.
All right, now, do you have anything else to say?
I do have some rebuttal testimony, yes.
All right.
Mr. Pierce, can you please go ahead? Mr. Pierce, are you a registered voter in Baltimore City?
Yes, have been for over 10 years.
And do you vote?
Yes, even in the midterm this past year.
You reside in the city, correct?
I have for about 15 years, yes.
And you take an income in the city?
Yes,
And you pay taxes on that income in the city?
absolutely.
There was a question regarding the concept. We didn't have a menu. Is there a reason for that?
We're still
Is that an
working it out.
Is that an issue?
No, just thought we could address it.
Okay, go ahead.
Why not? You said you don't have a menu prepared yet. Is there a reason for that?
We're just researching, working on it.
Is there some buzz you're trying to create with the restaurant?
Social media, yeah, the way people talk, sure, absolutely. Through social media, yeah.
That's it.
All right, any questions of this witness? Sarah?
No,
Okay,
other than
what you've said.
what I've said and
No,
there
I,
is no evidence.
I mean,
in the
questions
file.
on what he just said.
Well, and I would say if he's
Questions?
since, Mr. Pierce, since you claim to be a voter, is there any way you can present to the board your voter registration card as proof of such?
I don't have my voter registration card on me, but I have another address. Maybe you didn't know. That's my registration is probably linked to. I've moved recently in the last year, but it's out there. Whoever knows how to look up a voter registration should be able to find it. I don't know why you didn't, but I've been voting.
No.
Anything else? Okay. Commissioners, questions?
No. Everything was clear.
All right, are we ready for a decision?
Ready?
Anything else, sir? All right, the issue here, as it seemed clear to me, the issue is, of course, whether he qualifies as a transferee of this license, and I find that he does, based upon the facts which I find that I believe the applicant, Mr. Harlan, and that he is a registered voter and a taxpayer. And it's really the only clear issues that I saw raised, other than those two issues. I think I've already spoken on the issue of one of them, and I have nothing further to say, so other commissioners?
Well, it appears to me that he meets the qualification for the transfer. I haven't heard anything negative about his character, so I, too, is in agreement that he has met all qualification needed to okay the transfer.
And I concur, and I just a footnote that I think it's laudable that community folks would come in and ask that this board make sure that all requirements are met. And having pressed that issue, I do agree that you have met the qualifications for ownership, and I agree that there's nothing negative, and you do seem to be a fit and proper licensee, so I agree. And expanding, it just seems like there's a renaissance in that area, that there's some good things happening, and I wish you much success.
I want to introduce this letter of Ms. Schroeder as evidence out in the file.
6 or 7.
Oh, you have our decision, sir.
Thank you.
All right, thank you.
Thank you, Commissioners.
Tell me when you're ready. So we'll take a short recess.
It's okay. Is he okay?
And then he's back.
Yeah. Telephone's ringing.
Oh.
Can I move this poinsettia? Abe keeps kicking
Oh,
it,
there's
it's driving me
a
crazy.
poinsettia over there? Sure. Why don't we, if you hand it over, I'll sit it. Oh my
It's
gosh.
gigantic.
Yeah, I
But
think I can
Abe's
just sit
kicking
it on
the crap
table.
out of it, yeah.
Is he really?
Yeah.
We need it to survive.
It's not gonna make it through the day.
Right?
Thanks.
Where'd it come from?
Just right here, I don't know.
This is the whole decor for the room. That's Christmas. Equals Christmas. Big poinsettia, Christmas.
I felt like telling my Remington story.
Oh, you have a Remington story?
Yes, I do.
You're on the record, so.
Oh, better not.
Good one.
Hmm. Want me to tell it?
Maybe off the record.
You
We
have to
go
talk
into
to
this. Okay.
But press your button.
Press your button.
Because
You're
we're
being
telling it to the,
recorded.
we're telling it to the whole world.
I took my truck, into the gas station at 25th and Howard. And I parked it, and I reached over and entered the data into to get gas. And when I turned around with the hose in my hand, my truck was gone.
Are you serious?
No. So I looked at the entire gas station, and I couldn't find it. I said, I did drive in here. You know how you lose confidence in yourself.
Yeah.
And then I looked to the left and looked across the street. Now, a lot of men were waving at me
Oh,
from the
no.
other side of 25th Street.
No.
And that truck had rolled out of where I left it, all the way across 6 lanes of traffic. And then it went up on the curb in between 2 posts because there's a used car lot.
Yes.
Remember those new cars?
We need to talk to you for 2 seconds. I forgot, we didn't mention, we need to talk about Gary Madison. Hold on 1 second. I'm sorry, we need it for 2 seconds on the side.
Sorry.
What's going on?
Mr. Cadet. You get the next case?
Last one. You want it now? Yes. Suppose I lose, do I have to pay if I lose? If we win, does the board have to pay? I got it. You mean tell everybody else while I'm here? Yes. Make sure you guys got your check for 100.
How are you today?
Pretty good, how are you?
So far, good.
So far, good, yeah.
All right, so your truck went into the building.
When it went across the street, in past the two posts, all in between every new car and used car.
In between.
In between. And went all the way across that lot, missed all the cars.
Oh my gosh.
20-some cars, and then ran into another post. And that was it.
God,
They
you
said-
are very lucky.
That's what they said.
You are the luck of the Irish, right?
Yes,
If you
that's
don't mind my saying.
I couldn't believe it.
That is incredible. I know that. I mean,
you
that's
know-
where I get my gas. I go there
Oh, you do?
often enough. Yeah. Yeah.
One time I caught that outfit.
How did that happen?
And
I mean,
a little bit of graft in there, in that gas station. I hate to buy gas there.
a little bit of graft.
Well, what they do is they have one price on the post.
They do.
And they have
And
another
that's
price.
if you pay cash. And then another price if you're paying with a debit or credit card. Yeah.
Yeah, you see, I
they're all
was
doing
paying
that
with
now.
a Exxon card. And that's an Exxon pay station.
Yeah.
And they're not supposed to, Exxon card's supposed to give you the price on the post.
Yeah.
So he
yeah.
paid me cash back. When I,
Was this after you crashed the car?
Yeah.
The truck?
so he reimbursed me.
Oh
It was
my
like
God.
$3 or something, you know. But I didn't like it.
Yeah, I don't like that either. It's always a little funky over there. I mean, someone's been murdered on that gas station lot. I mean, this is years ago. But the operator now is very, very nice. Very nice.
They have a good mechanic there, by the way.
Oh,
He's
do
really
they?
Excellent.
That's good to know.
He's good, yeah. Of course, he only can do what he can do in the gas
Yeah.
station, but I've used him many times.
Oh,
He's
wow.
really excellent.
It's good to know.
Also, the price is right, you know.
Yeah, there you go. That's an amazing story about that truck, about your truck. That's
It's got the
incredible.
little bump down and a bumper to remind me of it.
Yeah.
Tell me when Jones comes, see how face a week.
Yeah, he's still back there. I guess he's still.
Everybody take their money.
Here he comes. Slowly, slowly.
Thank you, Judge.
You know, you're certainly welcome. Call the next case, please.
Chairman.
And we're back in session.
This is a hardship extension for Michael Fellner, a secured creditor at 1415 Washington Boulevard. This is a Class BD7, beer, wine, and liquor license. A request for hardship under provision 2B 10504D.
Nobody here for that?
He's coming.
Okay, enter your appearance, please. Enter your appearance.
Good morning, Michael Fellner, Pigtown Ale House.
You are attorney?
No,
You're representing? the,
myself.
Michael, oh, you are Mr. Finer?
Yes.
I see, all right. Be glad to hear from you. We'll swear the witnesses.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Be glad to hear from you, sir.
Good morning, Commissioners.
You know what the issue is here today is, you're clear on the issue. The issue is you're asking for another hardship extension on top of one you already received from us. And now you want to extend that hardship extension beyond what we gave you the last time?
That is correct.
On what legal ground?
If you'll let me read my letter, hopefully I'll answer that question. I also have some exhibits to present to you.
Well, I'd rather you just tell me. Simple question. What legal ground do we have to extend a hardship extension that we already gave you, which was the maximum under the law?
Then I would petition you to understand that the legal grounding would be that I am still continuously operating that business, and the law under the Maryland Annotated Code doesn't define what operations is, but I would suggest to you that renovating a premises would be part of a continuous operation of an alcoholic beverage establishment.
Well, I just have to unfortunately disagree with you. I think that the code is clear on what is an extension. You're actually entitled to a free 180 days, and then you ask for the code, you can ask for a 180 days hardship extension, which we gave you. And I believe that runs out on, the one that we gave you runs out on March 3rd, 2015, doesn't it?
I wasn't sure how to calculate that.
Well, we calculated from the time we started it.
Okay, since the last hearing, correct?
Well, when frankly, I don't recall what date the last hearing was, but whatever it was, we gave you the 180 days, and that runs out on March 3rd. Now you're coming in and asking for something which confuses me. What?
Sure. My situation is immediately after that last hearing, I hired a design firm, and over the past 3 months, found out that they were not producing the documents that I hired them to produce. And the first month, it seemed everything was fine. That's in these exhibits here. And all my emails with that firm are enclosed in the exhibit here, demonstrating that per your direction, per the commissioner and board's direction, I was going straight towards trying to get open. And only about 2 weeks ago, finally, was it very clear that this firm was not able to produce any of the documents that they were hired to produce. And now I'm in a position where I have to hire a new architectural firm to produce those documents. I've located one. That firm says they can get me those documents even over this holiday time in 3 to 4 weeks, and I should be in for permits. I'm already in for my facade permit. This is a rendering that was done, although the color and the name are going to change. This facade was done for me. I'm already in for the facade permit. I'm already in for historic tax credits. I'm already in for enterprise zone credits. I'd also put forward that I have also an exhibit here regarding a conversation I had with the then office staff of the liquor board when I was concerned about a deadline months ago, and they said, hey, don't worry about it. And that was a pervasive feeling throughout the office. Anytime I was rushing there to get something to them, their attitude was, hey, it's okay.
You know when you were talking about?
I have a note from February 18th, 2014. So I understand that we're in a transitional phase, and I'm before you here today.
We're not in transitional, sir. That's a bad word.
Choice of words.
Okay.
But I've had extenuating circumstances based upon purchasing the business and the license under the prior commissioners and the prior office staff that led me to believe that time was not such a great issue.
Well, let me say to you, first of all, I'm going to let you present your case.
Thank you.
But secondly, I also believe that perhaps the code itself should be changed, because the bureaucracies have entered into the picture which did not exist when that was passed back, I believe, in 2000 or 2001. And Senator Della was here and testified that since he passed, he's the one that introduced the code changes and interpreting it, that perhaps in those days, he said, and I believe that perhaps there are other circumstances which have occurred. For instance, the zoning board sometimes takes 90 days to answer, and we have a more active CHAP, Commissioners of Architectural and Historical Preservation, and permits sometimes are difficult to get promptly. And we understand that, so we have people doing everything they can. I'm not saying you're one of them, because I don't know all your facts, but people doing everything they can to comply with the law, but they find they run out of time, not because of anything that they do. But this commission is not in the position of changing the code. And it can only be done if the city of Baltimore finds that it qualifies to change it and is not preempted by the state or the state. The problem is, of course, if the state changes it, it wouldn't be, even if they passed it, it wouldn't be signed into law until the 1st of July. So you go ahead and, so I have to tell you that you're with me, this is my view, that you're not entitled to any more extensions past the 3rd of March, but I'd be glad to listen to you, and perhaps you'll change my mind, who knows. Go ahead, sir.
I agree with you. I think the code needs to change on, to take into account people that are in my situation or others that are going in the direction of opening or reopening, and they aren't just shuttered and closed. One of the points I will make to you is that my property is not vacated and shuttered and there's no plywood on the windows. I am actively there 2 to 4 times a week, working with various contractors and working with the designers to try to get this open. I've been moving equipment into the space, first taking it out. I've been moving chairs and tables into the space. I did get a demo permit and I did that work. So I agree with you. And that is why I attempted to see some light in the language where if this commission can see that I am not closed as a business operation, but merely I am pausing the work at the property to perform the renovations, which includes getting architectural design drawings, getting permits, hiring contractors, and then revitalizing the business, and hopefully in that same step, revitalizing that part of the neighborhood.
All right, any questions, commissioners?
I have some questions. I'm a little bothered. You made it sound as if the permit process is a long process and with difficulties in your case, and that maybe you could expedite this project if the permit process wasn't so hard to get through. Did I hear that clearly?
That is correct. In my experience, there's been maybe 3 challenges with the permit process. The very first one was the impression that I got from meeting with staff at the permit office that I would not need full architectural drawings to do the work that I wanted to do. Most of the work I want to do in the space is cosmetic alterations. And my electrician, and that's one of my exhibits, went down to the permit office with the understanding that you could apply for a heavy up permit of under, I'm not an electrician, but I believe it was 600 amps, and altering no more than 30 circuits, which was his scope of work, and they turned him away. So that was one instance of a challenge with the permit office, and that created a situation where instead of 6 months ago hiring an architect engineering firm, I only hired one after the September hearing. Now, the other thing is, I again have a document in my exhibits.
Well, let me follow up on that turn away by the electrician. Did they give you a fix for that? Why did they turn them away? What did you need to do in order for him to proceed with the work that you wanted him to do? And why would that process take a long time?
That's basically the permit office's possible discretion. I don't know. I then went to some others, and one of the things that I don't know for sure, but I went across, if you know 417 East Fett, there's the permit office on one side and then maybe the records office on the other side.
Planning reviews on the other
Planning
side.
and review.
Yes.
I went across there and asked to see any existing plans for my building, and they did not have any. So I only speculate that perhaps that made them nervous that when I said I'm not making any structural or material alterations to the space, they wanted to see what was there today.
I'm not going to win this conversation out, but just one comment and I'm leaving.
Yes.
Why would they have plans? If you never submitted plans to do some work, why would they have plans? That's my question to you.
Sure, that's a good question.
And they don't need to be apprehensive about anything that you might put before them based on the fact that they don't have plans for your building. But I'll let that go for now. Thank you.
Just real quick answer. The search for plans would be their search to see if any prior owner or operator had ever submitted plans for that space. So the building's been a restaurant bar since 1935, according to my research.
Judge, I hate to prolong this, but he just got me again.
Oh. I'm sorry?
That's not important. The plans are for the work that you're going to do. That's why they want to see what you are going to do at the location and whether or not, when they come out to inspect, whether or not you follow those guidelines. That's what the plans are for.
Right, so what,
So not for what you did in the past or what any other owner did in the past. It's for this point forward. But thank you anyway, sir.
Any other questions?
No questions.
I think the time is, no, excuse me, pardon, I didn't see you, sir. Are you here to testify?
I'm Heinz Murray, I'm Vice President for Citizens of Pigtown. I came here in support of the extension. He's kept us informed of what's been going on
You've
through
been
this.
sworn.
Yes, yes, sir.
Okay. So you're not objecting to his request?
We do not. He's kept us informed through email as well as he's presented to the community association and our members, and there's been broad support for the establishment. And it's just he's run into some roadblocks, as he has explained. And so, but we're in support of the extension if you so choose to do that.
Well, I think we're now going to call for our decisions, and I think I've already stated what I believe, that you're not entitled to any because of the statute. And it's not our job to either give you advice as to what to do or to change the law. Therefore, I find that you are not entitled to an additional amount beyond the March 3rd, if that is the correct date, whatever 180 days was, to 2015. And I deny your request. My vote is I deny your request for additional time today because of conflict with the code. And you
Still
can
submit my
put your
exhibits.
whole box in if you want.
Okay. I didn't know the appropriate time to do that. And if-
Sure.
I have 4 copies here. If you need all
Just give
4.
us one.
Okay.
We're putting it, maybe you want to,
I'll take a copy, because I know you
Okay.
went to the expense to create them, so I would like to, I'll
and I'll
take
put
one.
this in as Exhibit 1.
Okay.
Do you have anything else?
May I read this letter for the record?
Sure.
Dear Commissioners, I come before you today to petition you to allow me to continue with the privilege of retaining my liquor license while pursuing the renovation of the restaurant and tavern located at 1415 Washington Boulevard. I have previously come before the board with my resume, my business plan, community support letters, including support from the Neighborhood Association, zoning approval, and individuals willing to take time from their busy days to show support personally at hearings for my endeavor. I'm going to be brief, but wish to share with you sometimes time-consuming process of acquiring a building and a liquor license from a secured creditor and then navigating the process to renovate the space in a short time frame. In the beginning, the judge approving the secured creditor sale took nearly 3 months longer than expected to approve the sale and ratify the contract. That was the first delay. Subsequently, the zoning department brought up some questions about whether use of the second floor was permitted, which required addressing. Applying for a hearing before the BMZA and getting approval took another several months. My application was submitted in January, and official approval didn't occur until April, and that is an attachment is Exhibit A. During these early months, the attitude and direction given by the employees at the City of Baltimore's liquor board offices was one of giving me the feeling, as well as representing to me at time was, in fact, not an issue, and I need not worry about timely filing of paperwork or getting the renovation work done in a short time frame. My Exhibit B of my notes was a phone conversation I had with a representative of the office, and shows that she essentially said, "Don't worry," on February 18th, 2014. This attitude was reassuring at the time and took the pressure off of doing things too hastily. This attitude was pervasive throughout the office. After BMZA approval, I attempted to procure one-stop permits and was flatly turned down. I had been under the impression that minor changes that I was considering making, being mostly a cosmetic renovation, would not require full mechanical, electrical, and plumbing drawings. My electrician sought to pull more permits to upgrade the electrical service for better efficiency and safety and was turned away. See Exhibit C. At this point, I hired CK Design and Development to create the necessary MEP, or mechanical, electrical, and plumbing drawings, and other needed drawings for getting proper permits. Unfortunately, my head still hurts when I think about it, but CK Design and Development never produced the required documents that would enable me to get permits. And you can see Exhibit D for the lengthy history of my repeated requests for documents from CK, and the deceiving responses indicated things were initially going smoothly. I've now engaged the services of NW2 engineers to produce the necessary permit drawings, and even with the holidays, his firm feels comfortable with producing them in 3 to 4 weeks' time. In summary, despite my efforts, renovating an establishment in Baltimore City takes considerable time if one attempts to abide by all the rules. Furthermore, representation by the then employees of the Baltimore City Liquor Board office gave me the unambiguous feeling that time was not an issue. I continue to have support of the local community, both of individuals, businesses, and the neighborhood association. And Exhibit E has 10 to 15 letters of support from both individuals, the neighborhood association, as well as businesses in the area. I have invested a considerable amount of time and resources to this project, including having a new facade plan, which is enclosed as Exhibit F, and my larger scale drawing is here, as well as having approached CHAP for historic tax credits and the BDC for enterprise zone tax credits, which is attached as Exhibit G. I've also already completed my alcohol awareness class and have contractors lined up, to name just a few things I've done or still in the works, and that's enclosed as Exhibit H. In the interest of keeping this relatively short, I've not elaborated on every detail of my day-to-day operations, but we're happy to answer any questions that you might have. In closing, I don't believe the intent of the timing stipulations is to revoke a license from a party that is actively trying to renovate a property versus having abandoned the property or boarded up the property, which mine is not. And one might argue that renovation of property is not a cessation of operations, but merely a continuance of operations with the intent of revitalizing both the building and the neighborhood in which the property is part of. Please consider my extenuating circumstances and allow me the chance to bring a wonderful establishment to the historic Pigtown community that is safe, attractive, and desirable for all. Thank you.
You want that letter in evidence?
Yes, it's actually on the top of.
It's already there.
This is it?
All right,
Oh.
that's in, and also this is in, and the file is in, mark it. And do you have anything else you want to present?
That's everything, sir.
And you have no evidence? You have nothing to present?
Nothing to present other than we have a letter of support
It's
as
okay.
part of the file.
All right, time has come for an I vote no because of the law, so.
And again, your last extension was granted by this board. And I'm quite sure there was a comment, some type of statement made that this was, the law doesn't allow you to have any further extension. So the attitude that you may have derived from interacting with those in the liquor board office prior to that hearing may have been as you stated, but I'm quite sure after the hearing you had before this board, your attitude should have changed, because I'm quite sure you were told that this is your last extension, because that's what the law allows you to have. No, I don't need you to reply. So again, I'm with the judge. No further extension.
I might add, Commissioner Jones, you said not one extra day at the last hearing.
Okay.
Remember that?
And I have the transcript, I think we all have the transcript in front of me, and the exchange was, you said, Mr. Fowler, I hope you support that I'm trying to, the chairman says, all right, I vote yes, 180 days. Commissioner Jones then said, not a day more, 180 days. The chairman says, you heard that, didn't you? You said, I hope it's possible. Then the judge asked me, what did I think? And I said, I vote yes. So you got 180 days, and I think we're all understanding what your situation is, and I'll just speak for myself, certainly have some sympathy for your situation, but the law doesn't allow us to give you more time. And I just want to say that if you got the impression from any member of the liquor board that time was not of a concern, you got a misimpression, because they are very aware that time, all of what we do here is driven by time. There are deadlines by which certain things have to happen, and that is what this whole exchange of not a day more was all about. Time matters. Time is of the essence. You got the extension back on September 4. It does run out early March. That's about 3 months from now. So I think you need to do whatever you can do to, and I'm not giving you advice, but understand that you have no more time.
Your vote is?
And my vote is?
No.
My vote is no. My vote is no.
Good luck.
Yeah, best of luck to you.
Sometimes. All right, tell me when you're ready, recorder. Call the next case.
Lydia Fitzsimmons, James Shafley, Eric Butterfield. This is at Roxy's Restaurant, LLC, Frederick's on Fleet, 2112 Fleet Street. This is a Class B beer, wine, liquor, and this is a request hardship extension under 2B 10504D.
enter your appearance, counsel.
Certainly. Charles E. Brooks, BROOKS, 610 Bosley Avenue, Towson, Maryland, 21204, appearing on behalf of the licensees for Roxy's Restaurant Group LLC, 2112 Fleet Street.
Be glad to hear from you.
Thank you, sir. As you are probably aware, I think the file will reflect the closing of this premises on 6/28/14. I appeared before this board on 10/2/14 when I was granted what was referred to as the first 180-day extension. Therefore, Mr. Luchu's counsel for them filed a request for an additional 180 days, so that running the timeline, the closing was on 6/28/14, 180 days is up 12/28/14. What we're requesting is an extension to which will carry us to 6/23/15, that allowable under the law. The hardship is, obviously, the businesses had difficulties. They've invested substantial sums of money, and they ultimately had to close, which they have done. However, they have made every effort to sell the business and or assign it. They're working in conjunction with the landlord, hopefully to be able to obtain a new licensee to take over the premises. Therefore, we have respectfully requested the extension, if you would, for 180 days, carrying the same to 6/23/15.
Let's see if I get the facts right. You were here on October 2nd, is that correct?
That's correct, sir.
And you were here for what reason?
At that point in time, we had requested a extension, hardship extension
Of 180 days,
of 180 days.
which you got.
Well, I disagree with the board's determination because I believe there's an
No, what did you
automatic
get?
180 days.
Just tell me what your view is.
Well, my view is that should have been carrying it for the total of 360 days.
I think you're misinterpreting the law, because as I understand it, your first 180 days, you're allowed to operate not open. Allowed to be not open and continue to have possession of your license.
Yes, sir.
The problem comes, and the misunderstanding by a lot of people, is when you get to the next 180 days, you are entitled to ask for a hardship extension. So therefore, the two of them together amount to 1 year, which the code provides for. But if you start off with 180 days, you've exhausted your 180 days. You can't go back and claim the first period when you don't even have to ask for 180 days. That's what I think you're.
Well, the difficulty.
Is that your position? Is that?
No, my position is that we're entitled to the extension of 180 days. The letter, in fact, I wrote to this board subsequent to the hearing suggested to you at that point in time that indeed the first 180 days are an automatic period of time, that it is given by. Your Honor, you in fact at that point in time indicated that that was not true, that I had to come back for a second hearing. Therefore, we filed for a second hearing, and with that, requesting a 180-day extension. The 180-day extension comes about from and as a result of the termination of the first 180 days, which are, I would ascribe to you, Your Honor, automatic. And if you look at 10504 subsection D, it does in fact say additional or something to that effect.
All right, anything else, sir?
And the cumulative period, well, no, just that, 10504, I think is absolutely clear in that the first 180 days under subsection D, continued extension, we are in fact entitled to, with the explanation of our hardship is one of not having been able to acquire a purchaser and or someone to lease the premises, that we are now in a position that we indeed have to sell the business and or transfer the same. And the automatic period of time went from 6/28/14 to 12/28/14. The request that I am making is for this 180-day extension from 12/28/14, which would carry it to 6/23/15, in that it's not 1 year, it's actually, the code provides for 360 days.
All right.
Yes,
Where's
sir.
the licensee?
They said,
Are you the licensee?
Oh, no, sir.
You own it?
Attorney.
You own it. Well, we
I
had,
requested an extension and talked with Ms. Hesbeck, I believe.
They submitted a letter saying that the licensee could not come forward.
let me
this
say
evening.
to you that in the future, starting the 15th of January, licensees are required to attend all hearings.
I have been advised of that, but by Ms. Hesbeck when.
It's not your fault, you know, you're not under the rule yet, but,
Yes, sir, I
but we
understand.
like to see who the licensees are.
I most assuredly do agree, and I will tell you, at the last hearing, one of the licensees was present, Mr. Softly. However, I was advised that no one would be available for me today.
All right, questions, commissioners?
None.
Commissioner?
None, but more of a statement. I remember when you were here, and I do recall some confusion as to what it was you were asking for and whether you even needed to be present to make the request.
Yes, ma'am.
And I read your letter, and I remember reading your letter because you specifically referenced me and something
did.
that I said, and I didn't even think that that was an accurate reflection of what I said. But I do remember, and I do remember there was a little difficulty trying to follow what it was you were asking and whether it was a premature request. But so I'm just putting that on the record.
All right, anything else? Nothing? I believe the time has come. I think I've already stated, and I'll state it again. I vote no because I believe you have already received your 180 days under the code, and it expires very shortly.
12/28/14.
Yeah. And therefore, I vote no as to the, whatever it is you're asking, which I believe is contrary to the law.
You vote no under section, Article 2B, section 10504 does not allow for a 180-day extension?
Yes, I've already explained to you that you don't automatically get to 180 days. You do get a full year if you follow the code correctly. But you have, whatever reasons, I think I've explained it fully already, so I adopt what I've already said. All right, Commissioner?
I agree. My answer is no, for the same reason.
So I'm voting yes, because it's not, when he was here back in October, he was asking for an extension, and I don't know that, but he didn't need to be here and ask for it, because they had just closed June 28. He was looking ahead, and what I understood him to be asking for back in October was an extension, an additional 180 days effective from December 2014 going to June 2014. That's what I thought he was asking for, and that's what I believe he got. So I'm not even sure why he needs to be back here today.
May I
So
explain?
you need clarity.
Yeah, as I understood from the hearing was the fact that since it was premature, we were asked to bring this back closer to the date, and that they were told that at that point it was premature for them to have filed it in December, and they were told to bring it back to us, and that's the reason why we received the letter in November asking for the 180-day extension to be put on a December docket. And so they have not received a 180-day transfer officially from the board, and that's what this act would do, is to do that 180-day transfer. 180-day extension. This is the official request.
And this request would take it to June the 23rd?
Correct, and this is their first,
2015?
this would be their first and only request, because that was not granted in the October meeting.
And he says in his letter, Commissioner Dana Peterson Moore was of the belief that the first 180 days of a hardship are automatic, and interpreted my request as approval for the second 180-day period. I shared that view with the commissioner. However, the remainder of the board disagreed. Now, I really think that there's confusion, and I think it's on your part, and I think it's on our part too. But I don't imagine that as counsel, you would make a request that would deprive your client of the first 180 days. I didn't understand that to be what was happening.
The preliminary one that was following the trail, there's an attorney by the name of Stephen Luch who has been
Right.
speaking with the board. I'm retained for the purposes of the licensed beverage hearing to today in reference to the hardship. I appeared at the request of Mr. Luch at the first hearing. That's why Ms. Hedgebeth is so familiar with this, because, of course, she's dealt with Mr. Luch, has instructed him as to the sending of letters and requests, etc. I'm merely appearing for and on behalf of, and I believe my letter to the board after the last hearing clearly reflects that the board, at that point in time, the 180 days that was being requested was from 12/28/14 to 6/23/15. Certainly not as to the 12/28, because I believe under the law, you have 180 days, which is automatically granted, and that any extension of hardship has to be from that date forward.
Well, I totally disagree with you. I think it was clear what you were doing. And it was 180 days you were requesting on that date, and I just affirm I vote. She votes no. Votes yes. I vote no. Do you want to?
I don't want to change it.
All right, that's our decision, sir.
Thank you, Your Honor. See you upstairs.
Best of luck to you.
Michelle,
Yes, sir.
can I speak to you privately?
Yes, sir, I'm sorry, sir.
Do not be talking about me.
Yes, sir, I'm sorry.
Information. Or any other commission.
Yes, sir.
All right, call the next case.
It is Barbara Bullock and Dennis Hagan, Babs Inc., trade name BG's Pub. This is at 617-19 South Oldham. This is a request for reconsideration of a decision made on April 10th, 2014.
For the record, Melvin Jacobinski, 19 East Fayette Street, representing the licensee. This is a case came about as a result of a remand from the circuit court, and I'd like to make the first exhibit the remand order.
Go ahead.
Big Ten.
Ms. Hedgebeth has the package.
Yes, I do, sir.
Let's see, the last decision of the May 8th, 2014, the board found the license expired and there was no valid license to extend for 180 days. Why did the court send this issue back? I'm asking a question.
Because it was unclear as to what the board determined at the time, and I'll probably go through this thing one, if I can, one at a time. The first request, there's no doubt that on April 10th, 2014, the request for hardship came before the board, and it was the first request for hardship. And I'm enclosing a copy of this as an exhibit.
Okay, wait a minute, I got to catch up with you. Where did this come from?
It comes from the liquor board. That's not mine.
This is just received. This has been
What is
received as onto the file, and it's a
Who
letter.
wrote it? These people down here?
Yes.
And who are they?
This is a letter that was received this morning. That's why I wanted to make sure that it was added to the file. You can do that later, sorry, sir, I'm sorry.
Okay. Go ahead, sir.
So I think underneath there, the first time. This was the hearing, April the 10th, which is clearly indicates this is the first request for a hardship extension. That should, we asked for that to be made as exhibit 1, if we may. Number 2.
Now, the exhibit of April 10th, which was a hearing before the prior board, what did the board decide?
The board at that point did not entertain the request, but, and she was represented by herself at the time.
Did not
the
entertain what request?
request for a hardship.
Okay. Go ahead. So what, the board turned it down?
Turned it down. According, that indicates the first request. It came in response to her letter of March 17, 2014, in which she requested the request for hardship.
And she says she needs time to find a buyer in her letter. Is that
Correct.
okay?
And
All right.
once the board turned it down, went before Judge Copeland, and Judge Copeland remanded this to the board to make the following findings only. When did the petitioner file her hardship request? That would be the March 17th letter of 2014.
That's the one you just gave me.
Correct.
Mm-hmm.
Number 2, did the petitioner have a license in good standing when the hardship was filed, and I'll give to the board a copy of the license that was in effect at the time,
Which one?
indicating good.
And why was it said that was not in good standing?
I don't know. I mean, I don't, I just, the judge indicated that if these answers were,
This license you handed me was ended 4/30/2014.
correct, so it was in good standing, and it was, in effect at the time the hardship request was made.
By her, by letter.
Right. And lastly, if the petition did have a license, when was it sent to expire? So it was indicating it was set to expire April 30th, 2014.
That's what I just said, didn't I?
Well, I'm just reading what the order of remand
Oh,
was indicated.
I see. When did the petitioner file her hardship request? That's their first question. When did you
March
answer?
17th, 2014,
By her letter.
correct?
The second one, did the petitioner have a license in good standing when she filed the request? And
That's-
you've shown the license is yes, she did. Third question by the court, if the petitioner did have a license in good standing, when was it set to expire?
April the 30th, 2014.
And you pointed that out on the license.
That's the question we felt that the court was asking, that she should have been entitled to have her 180 days from that date.
But she came in here, again, asking, when was that, what was that date?
Was May 8th was a reconsideration.
That was a request for reconsideration of the board's decision of April 10th. And the board's decision of April 10th was what?
The license was not
In good standing?
in good standing, and it was a void license at the time. Which is what the court said, determine these questions because it was in effect.
This was not before us at all.
No. And I did not represent the licensee at the original hearing. The second hearing came.
Well, the questions that the court, I've just answered, it seems that the board was wrong, but I don't know.
Well, that's, I think, why the case was sent back.
But I don't know, maybe somebody else will give me some light. Sir, ma'am,
Yeah, I'm sorry.
you are the licensee? All right. All right, we don't need her testimony, do we?
No, it's because these were sent out specifically for those three questions to be answered, which I think we've answered them at this point, because at the time, I don't know that the court had in front of it the letter, the fact the license was good, and the fact that.
Well, we're going to
when it
introduce them
expired.
all as exhibits.
Right.
And do you have to give you this license back? You don't need any more, it's all.
No, that's out of your file, actually.
All right, we'll put it all in collectively as Exhibit 1.
Exhibit 1.
Hang on a minute.
That would be the questions that the court wanted answered, and I think we presented the testimony for those three questions.
Well, I read the transcript from the prior hearings, and the issue was that she had not operated as a bar since 2012, and that was the issue.
But I think.
I think she testified that she was last in business in March 2012, and there were no records of sales or purchases. The building that the bar is in was sold to Lu Xing Song at least by May 15, 2013, and that's according to the SDAT real property records. And she acknowledged when she was here before the prior board that she hadn't been in operation for almost 2 years. And if that is the case, that is why they denied the hardship extension, because they declared that she'd not been in operation for, I guess, 2 years, which meant that her license was no longer effective.
That may be so. That's not what the court has remanded the case here
Yes, the
for.
court sent this back to
For those-
find
for
out
those- for
whether
those
the
three
license,
questions.
whether
Wait
the
a
license.
minute, one person at a time.
The court sent it back to us to address the question as to whether or not the license was valid at the time she applied for hardship extension. And based on the transcript that was created at the prior hearings, I think the answer is no, and that's why they made their decision. She hadn't used the license in almost 2 years.
I would disagree with that, only because in the court, in their findings was relying on the Baines case, which says that the board can take people's money to keep a license alive and then tell them they don't have a license, and which was also put in the Yim case. And that was the reason why the court sent it back to say, let me answer these 3 specific questions. That's it. That's all we want to know is, 1, was the license in effect at the time? The license is in the file, was effective through to April 30th, 2014.
And the court doesn't mention the Baines case in its order. It just asks that this body
Answer those 3 questions.
whether the license was in good standing when she filed the hardship request. And I mean, just based on all the work that we've been doing over the last 6 months, we look at what is actually happening with licenses, whether they're being used or shelved. And this seems to me, based on the testimony that was, the record that was created in March, in April and May, that this is a license that essentially was on the shelf and not in use. The bar was not in operation. And I think the licensee testified that she certainly was not in operation after the building was sold. And the SDAT records indicate that the building was sold, or at least transferred, effective May 15, 2013. So by the time and there was no hardship request prior to March 17, 2014. So if she ceased business May 15, 2013, her license was good for 180 days, which would have taken her to November 2013. There was no application for a hardship extension until we got to March 17, 2014, but at that point, the license had already expired.
Well, that's simply the same thing that was in the Baines case, but I mean, you'll make your decision, and then we'll, if it's adverse, which I think that's where you're going, or affirming before, then we would then take those answers back up.
Okay, well, let me ask you this. Do you have evidence that contradicts the chronology that I've set forth?
Do not.
Okay.
And the other, I believe that, and I'm asking everybody, the prior hearing before the prior board showed that the license was not in operation. Is that correct?
That's correct.
No. So there's no challenge to that?
No, other than those questions, because I don't think the court had affirmed whether or not the license was valid and paid for. That's this case in Baines, which was decided by Judge Joseph Murphy, in which was a place called Murph's Tabernacle. And it was closed like for 4 years, and they were saying, well, you can't keep
Judge
taking.
Murphy was at what court level?
Court of Special Appeals at that point. He was a chief judge, and he wanted to know why it was called Murph's Tabernacle more than anything else. But
Was Murphy Tabernacle, that jurisdiction?
it was over in Patapsco Avenue when Senator
city.
Dell's area.
In the city?
Yeah. And then they were taking the money for 5 years for a license renewal, and they said, well, you can't keep taking the person's money for a valid license, and didn't offer to give the money back. The case was originally heard by Judge John Carroll Burns, and then went up on appeal.
All right, any other questions?
Oh, no question. I still stand on my decision back then. I mean, it wasn't in operation. Closed down for more than 360 days, and verified by the owner herself. License dead.
I concur. I agree.
And I concur also.
So in answer to the
So,
question.
but we're going to answer your questions, and in the record, I've already done it. You agree that I answered the questions?
Correct.
All right. And I don't agree with your interpretation of the law with respect to paying fees to keep a license alive.
It won't be the first time.
That's true. Good luck to you.
All right, thanks.
Thank you.
I don't know what you need these.
All right, now we're staying adjournment until 1 o'clock.
Could we go a little later? Maybe it's 12, it's 19
Sure,
minutes.
I didn't even look at my watch. Did they do that to us again?
20 of.
Okay, what do you want us to,
1:30 maybe?
1:30? 1:30 is fine.
Surprised out.
I've confirmed that date with Mr. Pika. He seems amenable to that date. We'd be asking, or defense counsel would be asking for Mr. Remark postponement in his favor till the 15th.
Your Honor. Is that agreeable to you?
Yes.
Okay.
And,
January
you
15th, sir?
also found out that the officers have been excused and knew that they didn't have to come down today.
Correct, sir.
And they're happen to be on midnight now.
They are a midnight shift, Your Honor.
And the 15th of January was the date
15th at 1 PM. And Your Honor, I would just ask that, for the record, it be noted that we were ready today to go forward if needed.
No more postponements, folks.
Yeah, I was just retained 5 or 6 days ago.
That's what I understand. All
I
right,
appreciate it. Thank you,
postponed
sir.
until the 15th of January at 1 PM.
Thank you.
Thank you, Your Honor. May I call the next case?
Yes.
Calling S&S Liquor Corporation, Stephanie O. and Lisa Randolph, trading as S&S. Your Honor, my officers are present, my inspectors are present. Liquor board is ready.
I don't seem to have that case.
So it was an add-on.
It was the first one, sir.
It was Thursday stuff for the 18th.
Is that what it is?
Oh,
That's
okay.
nice.
All right,
It's right there.
all right.
Thomas Hackers on behalf of the Liquor Board, Your Honor.
And Gary Naslund on behalf of this. We haven't negotiated sort of a plea.
All
Ma'am?
right. Go ahead, sir.
Your Honor, I've been in discussion with counsel, and we have agreed that the board would not object to a proposed recommendation of a 10-day suspension of the license and a $3,000 fine. I believe defense counsel would like to mitigate in regards to timetable for the fine. And with that, Your Honor, if defense wants to go forward with that agreement, I will stand down, not object to that, Your
Did
Honor.
you talk to police officers about this agreement?
Court's indulgence. I did not, I spoke with my investigators about it, Your Honor. If I can just address my police officers.
ahead.
Is that officers here? No, Your Honor, seems no objection from the officers, Your Honor.
And your position? That is your position?
That is my
Okay.
position. We've negotiated it, Judge. I have
All right,
some
now,
mitigation I'd
are
like to
all my
offer.
commissioners aware of this?
I'm aware of it. My only question was, what is the history of violations? Whenever the right time is to get to that, I'd like to hear that.
No, I can tell you.
Right time is right now.
Okay.
Sure.
Back October 4th, 2012 is the only violation. There were 3, 4.01 underage sales to a minor. Indoor smoking, 4.18, and 5.03 failure to operate as a tavern. Total fines, $850.
That was one time?
It was one time. Only date was October 4th, 2012.
Okay. Any other questions, Commissioner?
Not from me.
I'm good.
All right, present the case and place the facts in the record, and then we'll call upon you to, you assume the facts are correct.
Yes.
You go ahead, sir.
Preliminary motion, Your Honor, to enter in the evidence file I've included in the record, Madam Executive Secretary. May I proceed?
Yes.
On October 16, 2014, at approximately 11:15 p.m., Detective Akawande of Baltimore City Police Department Vice Squad entered the store known as S&S Liquors located at 2135 East North Avenue to conduct a BD7 investigation. While Detective Akawande was in plain clothes, upon entering the establishment, he made contact with an employee later identified as Ms. Janet O. He asked Ms. O if he could have a shot of Patron. In the bar area, Ms. O asked for his identification. Detective Akawande provided his Maryland identification to Ms. O. Ms. O inspected it, and gave it back to Detective Akawande and stated no identification, no bar. The detective asked to use the bar area again and was denied. At this time, the detective left the establishment and radio Detective Gatto and Detective Greenhill responded to the scene. At that time, Detective Gatto and Detective Greenhill entered the establishment. I observed the tavern area to be filled with boxes and used as a storage space. Detective Gatto advised the operator, Ms. O, that the tavern portion of the bar cannot remain closed as a result of Baltimore City's Police Department's investigation. BLC inspectors, Board of Liquor License Commissioners, inspectors were sent to S&S to investigate. On October 31st, 2014, inspectors visited the location and noted that the bar area, again, was closed and it was being used for a storage area. They also noted that the bathrooms were unclean and not ready for public use, and the sinks were unclean and not ready for tavern use. On November 6, 2014, inspectors revisited the location and observed that none of the previous items had been abated. And again, on December 1st, 2014, inspectors went out to the location and observed that none of the previous items had been abated. Make that motion to move into evidence. All events occurred in Baltimore City, State of Maryland, and that would be the Liquor Board's case, Your Honor.
No, Your Honor.
Then that evidence will be admitted as the evidence in this case. Anything else from, anything else, sir?
No, Your Honor.
All right,
Yeah, if I could. Miss O is here as the licensee. And what brings her to the court, Miss O's had a child about 10 months ago. And when she had her child, she was required to be a stay-at-home mom. Her parents, the gentleman in the back, was running the establishment. Miss O was unable to physically be present, and her parents took over the operation. Her father had had a stroke, and her mother was not in good health. And her father had difficulty moving around stock and handling things. And as a result, some merchandise basically piled up. And the father, since this incident, I went down, I met with him several times. It's been cleaned up. There's the toilet area. It's been cleaned up, and there's the bar area has been cleaned out. And they did hire an individual who's in the back, of Mr. Bryant. Stand up, Mr. Bryant, if you would. And he is lifting up the cases, the heavier cases, so her father doesn't have to lift things, and he helps out on a regular basis in order to move things around and keep things tidy and help out in the bar area. Miss O is very sorry for what happened here, but she's had her hands full dealing with a newborn child. I discussed this matter with the case. This is a very small operation. Her parents actually live on top of the bar to try and cut things down basically as a security matter, and that's where they live in this area. It's on North Avenue. It wasn't their intention to really violate the law. She has done everything she can now to correct it. She's more hands-on as will allow because of her infant. She had to get someone to watch her child today to enable her to be present here this morning. She's not trying to make any excuses for what happened here. She's sorry for what happened here, and I've explained that to the executive deputy secretary. I'd ask the court, I know that we've agreed on 10 days, and that 10 days would be from now. I'd ask you to consider it slightly less than that. It's coming up on the Christmas season. It's going to really hurt their rather small business a lot more than you'd expect. And the fine, I'm asking the board to give them some time to pay that. The 10 days and the fine.
How much time?
I think we'd like it about 90 days if that's possible.
Any-
I'll defer to the board.
Anything else? Questions, Commissioners?
I have none.
I have a question. Who is Lisa Randolph?
I don't know.
Wasn't Lisa Randolph, this is S&S Liquors? And it looks like Lisa Randolph might be a co-licensee? Yes?
Oh, she may be the Halifax City resident.
Well, is Lisa Randolph operating the bar? Is she in a position to operate the bar?
No, not at the moment. Well, my client's going to make arrangements to be more hands-on. She needs to get a child care arrangement in place.
I don't have any other questions.
Nothing else?
No.
All right, you have a plea agreement in this case, and the commission agrees with you. Therefore, I find that you're responsible for the charges and that there's a 10-day closure beginning today, a $3,000 fine payable over 90 days. The fine will be divided between the various charges. I'll let the staff and the council agree as to which amount of money goes to where, or we can make them all 3,000 and concurrent. Which do you want, sir?
It's a distinction without a difference, Judge.
Well, I'll make them, any suggestions from my commissioner?
Whatever they.
I would do,
The principal one is, of course, the first one. What do you think?
I would recommend 2,000 for violation of Rule 5.03,
2,000 there.
and I would do 250 for violation of Rule 3.06. 250 with respect to violation of Rule 3.07, and 500 for failure to cooperate.
Okay. Okay with that, Commissioner? All right, I'll adopt that suggestion, and with respect to all of three of us agree that as I said before, a 10-day closure effective immediately and $3,000 fine divided in the amount of $2,000 with respect to 5.03A, 250 for 3.06, 250 for 3.07, and $500 for 3.02. And the payment to be made over a period of 90 days or within 90 days.
Thank you very much.
Good, thank you.
May I dismiss my officers?
Yes, officers excused. And let me say to your client that we're going to be back to check.
All right, thank you.
And the file is Exhibit 1.
Yes, sir.
Thank you, Your Honor. May I call the next case?
Yes.
Calling Amigos Bar Incorporated, Pedro Maso and Carlos Navarro, trading as Amigos Bar. Thomas Akers on behalf of the Liquor Board. Your Honor, my witnesses are present.
Anybody here?
Good afternoon, Mr. Chairman. Peter Previs on behalf of the licensees. To my immediate right is Mr. Carlos Navarro, the licensee. To his right is Mr. Javier Navarro, his brother, and one of the managers of the establishment. Pedro Almazo is the other Baltimore City resident licensee. He's the prior owner of the premises. He is aware of the hearing, but is not here.
All right, swear all witnesses.
Just in case, just in case.
Stand up, raise your right hand.
10 day, $125 is the
Anyone testifying, please raise your right hand. Do you swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, nothing but the truth?
Right, okay, so it brings the whole total.
You're on.
Yes, thank you. Can you turn that microphone around? Can you use this one, please? Just calling my first witness, Lieutenant Colburn. Can you please state your name for the record?
Lieutenant William Colburn, Southeast District Operations Commander.
And how long have you been a police officer in Baltimore City?
19 years.
And did you happen to be working on November 2nd, 2014, approximately 1:23 p.m., 1:23 a.m.?
Yes, I was.
And what, if anything, were you doing that night?
I was conducting random checks with Liquor Inspector Karanakolis throughout the Southeast District. At this time, observed 400 South Eton Street, licensed liquor establishment at 1:23 a.m. Appeared to be open for business. There was what appeared to be a bouncer at the front door. There was an open sign.
And upon making this observation, first, 400 South Eton Street, what city and state is that located in?
It's in the city of Baltimore, state of Maryland.
And upon observing this individual outside of the location, what did you do?
Myself and Inspector Karanakolis, knowing that the liquor license for this establishment prohibited business from 1 a.m. to 6 a.m., stopped to further investigate. We stopped our vehicle. Inspector Karanakolis, because he was in plain clothes, entered the establishment a couple minutes prior to myself.
Now, how did you know that that particular institution only could operate till 1 a.m.?
I had several times in the past warned them for being open past 1 a.m. on other instances when I'd gone in to inspect the license.
So you were familiar with this location?
Yes, I was.
Okay. And upon, now you said, back up for a second, you said you entered first, or Inspector
The
Karanakolis?
inspector entered first.
Okay. Once the inspector entered, what, if anything, did you observe?
Approximately 2 minutes later, I entered the establishment, observed numerous alcoholic beverages, beer bottles, mixed drinks around the bar area. There were 2 people dancing on an open area in front of the DJ, which I could only describe as a dance floor, and loud music was being played. At that time, I ordered the establishment to close, turn the music off, and have patrons exit the establishment. There were approximately 12 to 15 patrons in the establishment at the time.
Now, those 12 to 15 patrons, where were they, other than the two that dancing, where were they seated?
Some were seated at the bar, others were standing, and as I previously stated, there were 2 dancing.
And the alcoholic beverages, how close an approximation were they to the individuals seated?
Inches.
Now, did you make any observations of any of these individuals consuming the beverages when you entered?
When I entered, I did not.
Okay. No further questions for this witness at this time.
Thank you. Lieutenant Colburn, I have 3 photographs of the, I believe it depict the interior of the premises. Could you look at these 3 photographs and tell me if they accurately depict the premises as it existed on November 2nd, 2014? Now, the first photograph is from the back toward the front, and there's on a diagonal is a front door, is that
Yes.
correct? And there's a pool table,
Yes.
and then a bar. The second photograph is from the front
From
to
the
the
front
back,
door, yes.
and the pool table's back there, and the back room door is in the far end of the picture, is that
Yes.
right? And this third picture is the same view with someone who is in front of the wall unit jukebox. Does that look familiar to you?
Yes.
Okay.
And the open area that I would describe between the pool table and the bar is where I observed.
Okay. And may I ask that those 3 photographs be admitted as licensees, I guess, group exhibit 1, Your Honor? I gave you one. Didn't I? May I? Thank you, sir.
Exhibit 1? Is that what you're on?
Yes, sir. Lieutenant, do you recall, there was no DJ there that night?
There was loud music being played. I don't know who was playing it. I didn't see anyone use a microphone or anything like that, as DJs sometimes do.
Okay, and you're familiar with the wall unit jukebox in the place?
I'm not familiar with
Okay.
it. I mean, I'd seen in the
All right,
photo, it appears that it's there.
You heard music, but at this point, you can't recall seeing an actual jukebox, DJ or someone on the microphone, right?
I'm not sure,
Okay.
right.
All
I don't know
right.
where the music was coming from. I did not see anyone utilizing a microphone.
Okay, and you,
I did
I'm
not
sorry.
see anyone utilizing a microphone.
okay, and now, with regard to the dancers, this picture looking from the back with the pool table in the foreground to the front, you said there's a little bit of an area between the
area
pool
between
table
the
and the
pool
bar,
table and the bar.
and there were 2 people that were dancing together?
Yes, there was 2 people.
Okay, and these people were dancing in a familial type of dance. They were dancing to music. They weren't performing an act for someone else to see. Is that correct?
That's correct.
Okay. Now, with regard to the day or the time of this incident, this was Saturday night, November 1st into Sunday morning, November 2nd, correct?
Correct.
And that's the day that the clocks go back from daylight savings time to standard time. Is that correct?
At 2 a.m. they do.
At 2 a.m. And that's pursuant to federal statutes, uniform all over the country, right?
Yes.
Okay. Now, with regard to the liquor license, you,
So from my own understanding, at 2 o'clock, then the clocks go to what?
Go to 1.
1.
okay. So, well, let me finish on that line. So when you testified 1:23.
Correct.
This was the first 1:23 under daylight saving time.
The clocks had not yet gone back.
Okay. Thank you. Now, the liquor license, I have a copy of it, and I would, you're familiar with the liquor license in this
Yes.
place? Okay. Respectfully request, Mr. Chairman, to introduce this as licensees 2.
No objection.
Okay. Now, with regard to, if you have a copy here.
It's at mine.
With regard to the other issue, the 2 dancers, the liquor license indicates continue to use first floor of premises for a tavern without live entertainment, correct?
Correct.
And it does not refer to dancing, either allowing dancing or not allowing dancing, is that correct?
Objection. I don't know if he's a zoning expert and could answer that.
Well, he's the enforcing officer in this case, overruled. He can tell us what he perceives as to be the law that he was enforcing.
It has been my experience from doing this somewhat over 19 years and considerably over the last 2 years, that any establishment that is permitted to have live entertainment and dancing, that is specifically printed on the license. And that is not the case here.
So you're not making a claim that they were allowing live entertainment. You're making a claim that they were allowing dancing.
But the board is making that claim.
Okay.
I witnessed 2 people dancing. I did
Gotcha.
not witness anything that I was considering.
Fair enough. You're just the facts, ma'am, right? Thank you. All right. Thank you, Lieutenant. I have no further questions.
Anything else, sir?
Just very quickly, showing you the photographs that defense counsel has entered into evidence. Where did you enter into the establishment?
We entered from where this photo was taken,
So
from this
from the
door,
rear- May I?
which is actually the front door.
Just using
This photo was taken from the front door facing the rear.
So you entered in from this
No,
location?
we entered from this door.
This door?
Correct.
Okay. And I'm just showing the commissioners which door that the officer entered into. And when you entered in from this door, you observed the individuals dancing right here, maybe about 10 feet away?
Probably 20 feet away.
How long were they dancing for when you entered the door? How long did you observe them dancing for?
A matter of seconds, at which time I conferred with the inspector. He advised me of his findings, and based upon the time, I told the manager, people behind the bar, that they needed to stop the music and cease operation for the night.
Was anybody else watching them dance?
Not that I recall.
Okay. No further questions.
No further questions. Thank you.
All right, commissioners' questions, if any? Next witness, if any?
I'm going to be calling next Inspector Karanakolis. Inspector Karanakolis, please state your name for the record.
Inspector Chronicles, Baltimore City Liquor Board.
And what is your job duties over at the Liquor Board?
Inspector,
And how long have you been an inspector?
about a year.
About a year. And as an inspector, were you working on November 2nd, 2014 at 1:23 a.m.?
Yes.
And what were your duties that evening?
Me and Lieutenant Colburn were driving around doing routine inspections and looking for bars that break the law.
Okay. And did you happen to come to a bar known as Amigos Bar located at 400 South Eaton Street?
Yes.
And what were the circumstances that drew your attention to that bar?
That they were open past 1 and there was a bouncer standing at the front door. And we knew that the license is until 1 a.m.
Okay. And upon observing that bouncer, what, if anything, did you do? After you made the observation of the bouncer, what, if anything, did you do after that observation?
Then went inside.
Okay.
So first I identified myself to the bouncer.
Mm-hmm. And did you have your badge present?
Yes.
Okay.
I told him inspector from a liquor board. I asked the bouncer, I'm like, why are you open past 1? And he just nudged his shoulders. I went inside.
What, if anything, did you observe once you went inside?
About 13, 14 people in the bar. They were drinking. They had drinks with them. There were 2 people dancing. Then I identified myself. There's a couple young ladies working behind the bar. And I identified myself to one of the young ladies. She was like, I'm the manager. And then she put somebody on the phone. I couldn't understand what he said, so I just hung up. Then Lieutenant Colbert came in, and I did my routine inspection.
When you went into the bar, you said did you observe anybody sitting?
Yes, there was a few people sitting at the bar.
And did they have drinks in front of them?
Yes.
And well, if you took notice, were any of the individuals consuming alcohol?
No.
You didn't observe that?
No, I didn't really pay attention. My focus was then to get behind the bar and grab the liquor license and see if, they had the traders, the alcohol awareness, and read their liquor license.
Okay.
And see what they were allowed to do.
And what were the proximity to the drinks to the patron sitting at the bar?
Inches.
Okay. All right. And how long was it before Lieutenant Colburn entered into the establishment?
Less than 2 minutes.
Okay. And were the individuals that were dancing continued to dance while before Lieutenant Colburn came into the premises?
Yes.
would be introducing, after making these observations, did you write a report?
Yes.
Okay. I'm just going to be introducing as evidence, this would be Liquor Board Commissioners, A1. There's a file located in the file itself. I can actually hand it up to you. This is just marked as A1.
All right, the file comes in Exhibit 1, and this is a part of the file already,
Yeah.
or not?
No objection.
It's
Part of the file?
that it's a yes, Your Honor. Yes, Your Honor.
It is or isn't?
It is, but I'm moving it into evidence, Your Honor.
All right, we don't need it. Okay, do you need the report?
No, Your Honor.
Okay.
No
Anything
objection.
else?
Court's indulgence. Now, did you, a couple more questions. Did you, you said you spoke to the managers?
To a manager.
At the time you spoke to the managers, what, if any, questions did you ask them?
The only question I asked is, why are you open past 1?
What was the response?
Really, they couldn't speak English.
Did
So
Did you notice
hard to
them?
understand each other.
Did you notice them, making beverages or serving any individuals?
No. When they realized I was the inspector, they got real paranoid. And they were, that's what, especially after Lieutenant Colburn walked in. That's when they got real paranoid and they were, trying to clean up real quick.
Okay. Did you see them making any kind of change or anything like that?
Yeah, the change was they were trying to clean up the bar and push everybody. Okay.
change cash-wise?
No, no.
Currency, anything like that?
Well, yes. When we were pushing them out, I told the lady at least, get the money for what they owe you for drinks, and some people did pay.
Okay.
And then they left.
Okay. So you saw the end of the transaction?
Yes.
Okay. All right. No further questions for this witness.
Thank you. Inspector, as part of your duties, you're also familiar that in addition to having the liquor license on premises, that the establishment should have their use and occupancy permit with regard to the city zoning.
They didn't have this there that day. The only thing they had the liquor license.
Use the mic, please.
This wasn't there. Their liquor license was there.
Okay.
The trader's license was there, and they had a health permit there.
Okay. Are you familiar with this document from the liquor board file?
Yes.
Okay. And you know what they, as stated on their use permit, what is and isn't allowed? And that's a copy of the use permit that's in the liquor board file?
Right, it says
Okay.
without live entertainment.
Without line of entertainment, right? May I introduce this as licensees 3, I believe? Okay. Inspector, are you familiar with the zoning for this premises?
No.
You don't know whether it's a B2 or a B3? Okay.
Excuse
Thank
me,
you.
I missed the question.
I asked the inspector whether he was familiar with the zoning. He said no, and that was it. Okay, and you would confirm what Lieutenant Colburn testified, that it was the change of the clocks from daylight savings time?
Yes.
And you saw 2 people dancing?
Yes.
You didn't see a DJ?
No.
You saw the jukebox playing? Or you heard the jukebox
I
playing?
heard music.
Right.
Don't know where it's coming from.
Thank you very much. I have no further questions.
Anything else? Your case.
No further questions.
All right, commissioners, any questions of the witnesses so far?
None?
I just want to get clarity. The testimony has been that this, you all entered the Amigos Bar at 1:23 a.m., and that was 1:23 a.m. on the clock. It had gone from midnight to 1 a.m. to 1:23 a.m., and 2 a.m. had not yet been reached.
Correct.
So there was no 2 a.m. and then a roll back to 1 a.m.
Correct.
So this is the first 1:23 a.m.
Correct.
Okay, thank you. I appreciate that.
All right, your case.
Thank you. Your Honor, I would like to be heard. I have the licensees and 3 of the ladies that were actually present that night, but there's really no dispute as to the facts. I would like to be heard with regard to the law. So I'd like to
Okay.
make a motion at
So
this
you
point.
have no, you want to argue now on your motion?
Your preference, Your Honor.
Well, it's up to you.
I would like to argue it now. if
Go ahead.
that's all- Okay. Now, with regard to the timing issue, the license as well as the statute doesn't speak in terms of when you can be open. It speaks in terms of when you have to close by. So the prohibition that's contained in Article 2B, Section 11503, which I have copies if you would like to see that, it says the hours may not operate between the hours of 1 a.m. on Sunday to 6 a.m. the following day, meaning 6 in the morning on Monday. It's daylight savings time. There's nowhere in the statute that makes a clarification for we're changing, fall back, the clock's going back. There is a provision for New Year's Eve that says you can stay open all night. I argue respectfully that they're in compliance with the code because as long as they close by the second 1 o'clock, they have complied with the statute. Now, if I can provide copies to the board. I didn't make 3 sets.
I'm sorry, what are you providing to the board?
I'm going to provide you with a copy. These would be the applicable sections of Article 2B. So if you started with 6-401D, 6401 creates a Class D tavern license. And it says, subject to Section 11503B2, the annual fee, and then it says in 2, in Baltimore City, the hours and days of operation for sale for the license are as provided under 11503 of this article. So it sends you into 11503. It doesn't say anything more. 11503B, because A is the special amusement license, it allows 2 o'clock. B says Class D beer, wine, and liquor license without amusement permit, Sunday supplemental license, except as provided in paragraph 2 of this subsection and 11304D3 of this title. No sales shall be allowed to a holder of a Class D beer, wine, and liquor license, parentheses, without amusement permit, close parentheses, between the hours of 1 a.m. Sunday and 6 a.m. on the following day. Now, just to finish the circle, that only speaks of Saturday. To find the rest of the days that you have to close at 1 o'clock are in 11303 D2, which says, except as provided in E, F, and G, which are not applicable. In Baltimore City, the hours are from 6 a.m. to 1 a.m. So both the language on the license and in the code says when you have to close by. Respectfully argue, as long as you're closed by the second 1 a.m. because of this anomaly, 1:59 is before 1 on this particular day of the year. So as long as they close before 1:59 standard time, they've closed by 1 a.m. I mean, daylight savings time, they close by 1 a.m. standard time. That's that argument. With regard to the dancing, Your Honor, the charge doesn't specify. The charge is 4.18, which is violating someone else's state, local, federal regulation. So I believe it's the charge is referring to the violation of the zoning law, not the liquor law. With regard to the liquor law, Article 2B, Section 10-202E provides, the only place it really talks about live entertainment is in 10-202E 2I, where it says, on receipt of an application for a new license, a transfer of a license, a change in the class of license, a request for live entertainment on the licensed premises, or an extension, to advertise and post and have a hearing. So there's no prohibition in the law with regard to dancing under the liquor code. With regard to the zoning code, this particular premises happens to be in a B3 zone. A B3 zone would allow as a permissive use tavern with live entertainment and dancing. The use permit and the liquor license, which copies the language from the use permit, say that you're allowed tavern, no live entertainment, but don't prohibit the dancing part. Since it's a permitted use and it's a tavern and a B3, I don't see where it's prohibited under either the zoning code or the liquor code. One other issue that we've had this discussion with Inspector Jones, or Commissioner Jones, but in his hat as an inspector, is with regard to the definition of live entertainment under the zoning code. Your Honor, I've made a packet of the applicable provisions of the zoning code with the definition of live entertainment. If this would be of help to the board, I have copies here. In the zoning section, first, let me see here, I'm sorry. I thought I made two more. No, that's that.
I don't really need it, Judge. I just want to make sure everybody has a copy.
I'm sorry, Mr. Commissioner, I didn't.
Go ahead.
Oh, I have one more here. Hmm? Okay. All right. Oh. Okay. 6401, subtitle 4 is the B3 zone. If you flip to the next page, in 6406 are the permitted uses. And if you go to the next page after that, subsection 65, taverns including live entertainment and dancing. I provided the zoning definition of live entertainment. Before I discuss that, I'd also provided the definition of tavern and tavern including live entertainment or dancing.
I didn't understand your last sentence.
Okay. I provided the board with three definitions: live entertainment, tavern, and tavern dash including live entertainment or dancing on the last page. Now, with regard to the definition of live entertainment, it says live entertainment means any one or more of any of the following performed live by one or more persons, whether or not done for compensation and whether or not admission is charged. Musical act, including karaoke, theatrical act, including stand-up comedy, play, review, dance, that's going to be the question, magic act, disc jockey, or similar activity. The dance that's referring to is a dance performance, the Alvin Ailey dancers, the Bolshoi Ballet, as opposed to people dancing. The zoning definition doesn't define people dancing in a familial way. To make an analogy, there's a Fourth Circuit case dealing with whether dancing is permitted or is covered under the First Amendment right of expression. And that case is Willis versus Town of Marshall, North Carolina, 426 Fed 3rd 251, 2005. A copy for the board and for council. Basically, what occurred in this case was this small town had a weekend public dance in the public square, and there was a particular woman who danced suggestively and showed her underwear in front of children, and she was banned from.
This is a question, Amendment 1 case?
Right.
But that's what the
this
case was.
case provides logic for the difference between two people dancing and a dance performance as
Free expression.
Right. And so this woman was prohibited, and she filed a 1983 action and lost, and they said that her dancing to the band was not protected conduct because she wasn't performing for someone else. She was just dancing, and therefore didn't have First Amendment protections. On page 6 of this opinion, it says, it is well established that the First Amendment protects expressive conduct as well as pure speech. We have long recognized that the First Amendment's protection does not end at the spoken or written word. Conduct may be sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. There is no doubt that under some circumstances, dancing will amount to expressive conduct protected by the First Amendment. For example, most forms of dance, whether ballet or striptease, when performed for the benefit of an audience, are considered expressive conduct protected by the First Amendment. Down to the next paragraph, first sentence. This court has stated that recreational dancing, although containing a kernel of expression, is not conduct which is sufficiently communicative to bring it within the protection of the First Amendment. So this case makes the distinction that I've been trying to explain in the zoning definition, that where in subsection 5 it talks about a dance, that is the strip club or the Bolshoi Ballet or the Alvin Ailey dancers. The people dancing, that is a zoning issue, but it's not defined in the definition. It's just, it's non-expressive familial dancing. It's in a B3 zone. Live entertainment and or dancing are permitted. What's on the use permit is tavern, prohibiting live entertainment, but not prohibiting dancing. So I would argue that it would be allowed. Thank you.
Any comment?
Yes, first to the time issue. 1 a.m. is 1 a.m. is 1 a.m. And nothing that Mr. Priebus has presented to this board indicates that his client was not operating an establishment that was open, serving patrons after 1 a.m. It does not matter whether at 2 a.m. the clocks go back to 1 a.m. 1 a.m. is 1 a.m. is 1 a.m. They were operating at 1:23 a.m. The testimony is pretty clear. And I would just point the board's attention. And I would appreciate in regards to decorum, if defense counsel has all of this case law and zoning law that he's going to cite, that he would try to provide it to me beforehand, as I have provided him and kept our files open as well, and made any kinds of copies of any kind of information I may have, and I give to him beforehand. I would point the board to 11302D, which talks about on sale beer, wine, liquor licenses. And this is just more evidence, more indication of the fact that D licenses are to operate from 6 a.m. to 1 a.m. 1 a.m. is 1 a.m. is 1 a.m. And nothing that defense counsel has said indicates that his client wasn't serving alcohol after 1 a.m. Defense counsel even admits to it. Second issue, as far as the dancing is concerned, counsel cites a Fourth Circuit case dealing with a North Carolina issue. It has nothing to do with Baltimore City. Second of all, defense counsel is trying to state that the zoning code can be used to usurp liquor board rules, in that if in a certain zone live entertainment is allowed, you don't need to apply to the liquor board for a live entertainment license, because you can just go to the zoning code, forget what the liquor board says. That was not the intent of the zoning code, to usurp the liquor board rules. And even if the defense counsel wants to apply the zoning code, it specifically states in front of you that dance is considered live entertainment. Now, counsel wants to differentiate between dance for whether it is a vaudeville dance or a striptease dance, and dance between two individuals in a bar. The code is pretty clear. Dancing for not have, and I think I'll try to quote a law here, the zoning code that he refers to. Live entertainment means any one of more of the following performed live by one or more persons, whether or not done for compensation. Even the testimony that you've heard, the testimony that you've heard, nobody said that the dancers are being compensated. They were just dancing. You've heard consistent testimony as to the fact that this matter happened at 1:23 a.m. and the individuals were dancing. Your Honor, I'll leave it at that.
All right, with respect to your motion, with respect to the time period and the question, the law is clear. 2 o'clock goes back to 1 o'clock, and you were in violation, and I think it's as simple as that. With respect to live entertainment, it's very interesting, the definition in the liquor code, and I have to also point out that this has been the policy of the liquor board for as long as I can recall, that dancing is a violation. But in any event, looking down the acts, 3 come right out in front to me: play, review, and dance, meaning an insignificant type of activity beyond just serving alcohol. And may I remind you again that with respect to your Supreme Court case, that in licensing with respect to liquor is a privilege, not a right. It's not the constitutional right under the First Amendment at all. And the right to administer liquor distribution in all states and all counties has been long asserted that it's their privilege to decide what if that the local jurisdictions can do. In this case, Maryland and Baltimore City has clearly, in my opinion, established that dancing is a violation. Now, whether we agree with it or not has got nothing to do with it. It's kind of a shame in some ways that two people who get up and dance and they violate their license. But that's for mitigation, perhaps. In this particular case, I find that the violation is clear. Therefore, your motions are denied. Do you have any evidence?
I submit at this point, Your Honor. With regard to the sanction involved.
Okay, we're ready for final decision.
Right.
All right, I find the violations are clearly proven, and the case is that what punishment should be. As I've already said, with respect to the dancing, I don't really get totally upset by that, but I find it is clearly a violation. And but the fact that you were open, I think that the evidence is also clear that your ownership and licensees knew they were violating the law. Therefore, the question is what to do. Any record?
Yes, Your Honor. June 6, 2011, violation 4.10A, purchasing from other than a wholesaler is a fine of $400. December 7th, 2010, there was $125 paid in lieu of a fine. It was
7th of December 2010?
Yes, sir.
We're going backwards. What was that violation?
It was a pre-conference violation, Your Honor. I am unsure. It just said $125 paid in lieu of a fine.
Trader's license, I believe.
Trader's license.
Okay, go ahead. Anything else?
Those are the two, Your Honor.
Does the board go back 3 years or?
We, under my administration, we go back as de novo to whenever it starts. And do you have anything you wish to say in the mitigation?
Your Honor, with regard to the hours issue, honestly, this is the first daylight saving time case I've ever had. There aren't that many Class D licenses around. I would like to just suggest that the matter be handled in the future proactively instead of reactively, and that people be reminded that the clock only goes back at 2 and it doesn't go back at midnight, as a lot of people think, and that
Who are these people?
that don't know.
I mean, I've always been aware of it. I don't know what you're talking about.
Right.
You make it sound like the large number of people are being fooled by daylight savings time going to an end.
I know most people
And in particular,
turn their clock back before they
wait a
go to bed.
As he always says, my recorder says, talk one at a time.
I'm sorry.
And especially bars who are very sensitive to times. And I don't know anybody that doesn't understand daylight savings when it ends. And the only direction is people are not sure sometimes whether they go forwards or go backwards, but they always find out because they get to church on time and everything else.
I find that argument
It's the first time
persuadable.
I've ever heard it come up. I know, I don't know, but my perception is that most places think the regular license go to 3 and the 1 o'clocks go to 2 o'clock.
Why don't you tell me about your clients with respect to mitigation?
Thank you, Your Honor. Mr. Carlos Navarro is the owner and the licensee. He bought this place about 4 years ago. It's a very quiet neighborhood
You ever had any
corner
problems in the
bar.
community?
No problems that I'm aware of, Your Honor. And his brother Javier is there day in and day out.
Michelle, any problems in the community you noted in the record?
There, sir, there are 3 letters that were submitted.
All right.
Sorry.
Do I
They-
have them?
Yes, I can pass them to you right now.
They weren't in the file when I checked the file at the end of yesterday?
They were just received today at the hearing.
I'll certainly give them to you right now as soon as
Yeah.
I see them.
Object for the record.
Oh, these are the ones I already looked at.
Those were received.
Here you
Yeah, those were the 3 that were received today.
Okay. Since you've had a chance to look at them, I'll be glad to hear from you. Did you notice the one letter says, previous problems with this bar? See that?
I do, and I'm taken aback.
Your Honor, if Lieutenant Coburn would be able to provide some testimony as to history of the bar from his direction.
Yes, with respect to the mitigation, I'd be glad to hear from you. Sir, you've already been sworn. What do you have to say?
Reference this establishment, Your Honor, at least 3 or 4 times. I have warned them about staying open past 1 o'clock. One time in the past, earlier this year, that was documented in a police report. But this is not the first time that they have refused to comply with the restrictions of the license and had been warned prior, so they can't say they weren't aware.
Anything else with respect to community problems, and you have any knowledge of that?
I know there has been at least one that I heard call for service from the community for this. It was after 1 a.m. where we received a 911 call from a citizen in the community stating that the establishment was open after hours. That's how I initially became aware of the license expiring at 1 o'clock, that it was a D license.
All right. You go ahead, sir. We're on mitigation.
With regard to community complaints, we're totally surprised. We haven't had any indication of any issues. It's a small, extremely small, you've seen the pictures, quiet place. With regard to the closing, I know the board has ruled, and they understand this is a D license, and there aren't that many of them, and the law hasn't changed yet, and I would hope it would. But I respectfully suggest that this is a fine issue and not a closure issue.
Anything else, sir?
No, Your
And
Honor.
with respect to punishment in this case, I rule that the facts are clear, as I have already stated, and found the licensee responsible. And the punishment that I, on behalf of myself, give is that in view of the fact that there have been minor problems in some ways with respect to this, that there will be a closing of 4 days established now, and a fine of, what's the maximum fine here?
Since this is the $3,000, Your Honor, since this is the second offense.
A $3,000 fine because of the fact.
Sorry, I didn't mean to interrupt, Your Honor.
What did you say?
Because it's a subsequent offense, it's a fine up to $3,000.
Yeah. I'll have a $3,000 fine in view of not closing more than 4 days. 4 days closing because of the holidays coming up. My closing is like a warning rather than a punishment, that don't do it anymore. And a $3,000 fine, how much time do you need to pay it?
30 days, Your Honor?
30 days. My fellow commissioners will now vote.
Well, listen to the testimony in reference to this being located in the B3 district, and that dancing and live entertainment, which covers dancing, is allowed. Even if it is allowed, you still have to get the approval from zoning to have dancing at the location. Just because it's in the book, it doesn't mean that you can have it. You have to apply for it, and it has to be signed off on. And even after that is signed off, you still need approval from the liquor board to, it must be listed on your liquor license, which neither one of those things were, neither one was taken care of. Because of that, and the report, the testimony here, I agree with the chair that 4 days closure and $3,000 fine. And this situation here is serious. You can't just take it upon yourself to stay open as long as you want to. You pick when you want to violate the law. You just can't do that. You must be a part of the community, live within the community, and get along.
I agree with my fellow commissioners. I think the reason that this is a first daylight savings time case is because that everybody, it's the opposite of what you argue. I think everybody knows when the clocks go back. And, you know, it's a clever argument, but it doesn't make a lot of sense to me. So it's clear that there was a violation, and so I agree with with the fine that's been imposed and the penalty.
All right, folks, you have our decision.
Thank you. Would the board consider its authority under 16101 to issue a stay while this is pending?
No, in fact, I'll just do the exactly opposite. I'm opposed to stays, and I want the circuit court, in the event these cases are appealed, to understand it's the board's position, and it has been our position, that stays undercut our authority, undercut what we're trying to do in the community, and not hearing the facts in these cases, because these stays that before the Circuit Court of Baltimore City come up within days after our decision with absolutely no knowledge of the facts to the judge in the circuit court. And as a judge who used to serve in the circuit court for 24 years, I'm aware of what I'm talking about. And by the time that the testimony is written up, much time has gone by, and the judge has no knowledge at the time he's making the decision of the stay with respect to the facts in the case. And this is very upsetting, because we listen to these cases carefully, we hear from the community, and then suddenly, after a 1 or 2 minute or 5 minute hearing, the circuit court, we get reversed and the stay is lifted. And I'm upset about that, and want to make my position clear on it as to what it is. Thank you very much, sir. We're staying adjourned until next week.
Thank you.
Folks, good seeing you all. And we'll go. You like that?